How are you doing?
Fine. How are you?
I'm doing good.
Great.
Hello, everybody. We'll be getting started here in just a few minutes.
You're going to have me on YouTube. I don't know if I can have a bourbon.
Hey, I got one too. Cheers, everybody.
I'm like Justice Kavanaugh when they did his confirmation hearing when they were pounding on him. He says, I like beer.
I'm a vodka guy.
Oh, I'm a bourbon guy. Better get water though.
How I'm standing off over here. It's hell of a lens. Okay. Hopefully everybody can hear this clearly. Do the best we can. We'll be streaming on Facebook also.
Somebody got a Facebook going?
Yeah, we got it all going.
Can there be a share party on that?
I've got that event that I posted an event for
Under what page?
It is.
Ryan Scout.
Just tagging it.
Oh, you got to see. I'm not into the law. Obviously, did you have a conflict?
No.
Sure.
Yeah, I'm gonna show you that.
I thought it was going to.
Here's the YouTube link. Okay, here it is.
It could be a Facebook link too if you go into the.
It says watch video, but I don't know if you can share. To do a share party. I'm not that technologically advanced.
Yeah.
I couldn't figure out how. I was just trying to figure out how you can't do a share party. You see what I'm saying? That's okay. That's fine. Yeah. That's okay. I can eat it. The shrimp small. What? Thank you. You guys ready to go?
Yes.
All right. It's only 3:05. We're right on time. For those of you that don't know me, I'm Tom Devore from the Metro East. I've been spending the better part of the last 18 months of my life trying to help. One time it was small business owners, and now it seems to be that it's the schools that are the super spreaders this year. So I've been doing this all along, trying to help people understand their rights and what their choices are, etc. That's really been my goal. A lot of times you'll see that the political polarization likes to couch that as anti-mass or anti-whatever, that somehow or other they politicize it. And for those who have listened and watched what I've been doing, there's never been a political slant to it. It's been, let's talk about what the law says, and then we'll make decisions accordingly. Whatever your policy decisions are really none of my business, to the extent that I'm not a member of that immediate community. So the short version about me, I don't spend a lot of time on it, is I'm a first-generation college student. My mother was on welfare, nice lady. didn't ever try to go any further in life. My father was on disability. He had a drinking problem. We had a broken home. And by the time I became a teenager, I realized that if I wanted to do something better for myself, that I had to work hard. And I did. I ended up getting into college and did well, and then went on to law school when my children were 5. I have triplets who are now 18 years old in college, and they were 5 years old when I went to law school. So, I knew what it was like to go from a background that I appreciate and am not critical of, but to go through all levels and get to where I'm at now. And the only way that I was able to accomplish that is because of the foundation of what this country was founded upon, right? I mean, without that, those opportunities would not have existed. And so what I've seen for the last year and a half is an erosion of that foundation, which is what caused me to step up and say, I can't sit by and watch this happen, because I was able to appreciate it. And again, I saw that at being at risk. As for my kids, it's sad in the state of Illinois with what we're dealing with is, I had 3 National Honor Society students and 1 Illinois State Scholar. And again, when Governor Pritzker had to sign that Illinois State Scholar certificate for my daughter, she kind of chuckled and said, I wonder if you noticed who I was, Dad. And so, but anyway, what's unfortunate is when they got out of high school, they all went to college someplace other than in Illinois. They did not want to go to college in Illinois because they have watched, as most of our children have at all levels, what's been going on the last 18 months. And they were old enough to really kind of appreciate it. And they're like, we're not even going to go down that path of going to a school here, Dad, that's going to try to force us to be vaccinated or anything. They made their own choices. I said, I don't want you to do that. But if you choose to do it, you're a young adult now. I said, your dad certainly can't stop you. So they went to school, all of them in various different places in Missouri. So we're losing that talent, and that's unfortunate. Getting back to, again, this whole issue of what we're dealing with, and what we're talking about today as it relates to schools. If I could ask any one of you, if you want to volunteer, what is the issue that we're talking about right now as it relates to schools? Anybody want to take a shot at it? What's the issue? Freedom, absolutely. But if we're going to talk about what is the issue relative to what school districts are dealing with right now?
Local control.
Local control, that's right. Against what?
We the people.
Overreach.
Overreach by who?
Government.
Yeah, who said that?
Jelly Belly.
That's right. You will see, if you watch the articles that are going on right now, and it's publicized by the media, school districts defy governor's mandate, right? Guys, legally that has nothing to do with anything that we're talking about right now. Or you'll hear the governor and his people say, the courts for the last 18 months have said that everything that I was doing was fine, so why do you still keep arguing with me? How many of your school board lawyers have told you that? Right? And I'm here to tell you that what we're talking about today has nothing to do with any court case, except one that's actually going to help what we're talking about today, not hurt. You guys heard about the Hudsonville school case? How many school lawyers said that Hudsonville case is the basis for which you have to listen today? Right? Wrong. All of those court cases before, except Hudsonville, which I will get to, dealt with the proposition of, can the governor create these 30-day fictions of an emergency that expire at the end of 30 days, and he starts all over again, and then it expires, and he starts all over again, so he can perpetuate that emergency and continue with these whatever level of power he has under these emergency powers the legislature's given, as long as he feels like it. Those court cases are everything that was dealt with last year, and at least for now, and it hasn't made it to the Supreme Court, but at least for now, the courts have been inclined to say, at least as of a year ago, you can continue to play that fictional game of 30-day bunny hops. But cases that deal with, regardless of that, what is the extent of the ability of him to do anything with an executive order, and how does it apply to citizens? How does it apply to other bodies of government? What can he do and what can he not do? That's never been in a courtroom to this extent, okay? Except one time last year in August of 2020, right? That was a year ago. You think the optics of this issue that we're talking about today are the same now as they were in August of 2020? In the community as a whole in the state, you think that people are seeing it the same way? Absolutely not. When I was talking about this a year ago, you couldn't get school boards or parents really because they were scared, right? They were paralyzed by, we don't really know what we're dealing with here, so we're more willing to acquiesce and go along. The law was the same then as it is now, but people are more frustrated and have finally gotten to the boiling point to where they're pushing back and asking questions. And everything that I'll talk to you about today is merely to ask questions, and I'll talk about those questions. But you guys are aware right now, ISB is saying that if you don't follow this state guidance, we're going to suspend your recognition status, put you on probation. How many of you are on probation right now? Okay. And I'm going to suggest to you that that is an appearance of probation, but we'll get to that. Well, and so what that putting you on probation is, what that means in the eyes of a law or court is that they have a remedy within the documents, the laws themselves, to make you listen. They have a way to make you comply, again, allegedly, according to them, under the provisions of the law and the rules, right? Last year, when they had that Hudsonville case in front of Judge Grishow in Springfield, they took the exact opposite position. They said, Judge, we need you to use your power, because courts have some authority too in order to make you do something. But the court can only invoke its power under those circumstances if you say to the judge, I don't have any lawful way to make this happen. I need your help. So ISB went to the court last year in Springfield, and I'm going to show you part of that order that was entered. It says, Judge, we don't have a remedy, a lawful remedy to make them listen. Please use your power. And the judge, again, on that day, in that courtroom, agreed with them. It's not precedent. A judge in your county or in your part of the state may say, no, I disagree. I'm not going to do that. But that judge on that day did. It's not precedent. Any lawyers in here? Anybody? What that means is that a different court are they bound to listen to that. Now, if that was the Illinois Supreme Court, all of the lower courts would have to listen and say, yeah, that's the law. One judge in a county in Sangamon County on that issue, it's not binding. But what's important for you guys to think about, and the school lawyers won't tell you, is that the judge only did that because these administrative agencies said, we don't have any way to enforce this. And now here you are a year later, with the law being exactly the same, going, oh, we have a lawful way to enforce it through recognition status, probation, or revocation. If they would have told the judge that last year, she would have said, well, go get to doing that. Don't come looking to me for help because you have a way to enforce this. You see how that's inconsistent? And we're going to use that against them should this thing continue. And I'm going to show you that court order, that's part of that order in a little bit, but I want to let you guys know, not only is the governor's order or cases to date, they always say, well, Tom had 69 cases and didn't win any of them. I started laughing going, I had about 5 cases, and whether they won or lost, none of those cases are over. There was intermediate rulings that said, and I disagreed with the court, but so be it, that he can create those 30-day fictions. We were never in a courtroom arguing what is the breadth of his power, what can he do and what can he not do? Can he take control of your local school district somehow and make you listen? That's never been in a courtroom. So that's important for you guys to remember, okay? And again, the issue of the Hudsonville case, not only is it not relevant or binding upon your school districts, it stands for the opposite proposition of, how can you tell me you've got power today, ISB, when you told them a year ago you didn't have it? So moving on now, getting into the details of that, what I'm going to be doing is providing you guys information in school districts. I don't care what your policy decision is. You say mass required, you say mass recommended, you're on probation, not on probation. There are still questions to be asked, and the questions today have nothing to do with Governor Pritzker. The question is solely limited to, does the Illinois State Board of Education, with the laws that exist today and the regulations in Title 23, how many know what Title 23 is? Okay. Is there authority in there for ISB to put you on probation, ISB or the superintendent? Because the superintendent operates in a separate capacity as the state board. Does either of them have the authority as written today to put you on probation? Can you have them turn that down a little bit, please? To put you on probation or to suspend recognition for not complying with some state level guidance that they're trying to compel on you by an executive order or Department of Health guidance. That is the question, okay? There is no broader question than that. Any small business owners in here? Bar or restaurant owners? Anybody? You remember what, you got one? You guys remember what happened last year with bar and restaurant owners? You couldn't be open because you were the super spreaders. I had 1,000, this is an analogy I want you guys to consider. I had, again, 800 to 1,000 small business owners at various times throughout 2020 in 80 plus of our counties. How many of those business owners do you think a court order closed because they were not listening to the governor's executive order? You understand the question? How many times do you think that happened? Zero. How many times do you think the governor's office or some state level agency took one of those business owners to court to try to get them closed for not following his executive order? Zero. How many times did he threaten them? A lot, right? I was in Rockford, Illinois last year, and I said, it's 750 business owners. This room was packed full of business owners looking to survive. And I asked them a question. I said, how many of you listened to Governor Pritzker on television on March 16th of 2020 saying that I'm issuing an executive order, and if you're not essential, think about that. It's the United States of America. If you're not essential, do you know who made the determination of essential versus non-essential? Who do you think made that decision? The Department of Commerce and Economic Opportunity, an administrative agency of economics, drove essential versus non-essential. You can't be open. And I said, how many of you listened to that and closed your business on that same day? Every one of those business owners raised their hand. And I said, how many of you lost tens, if not hundreds of thousands of dollars because of that? Because we're in October. Every one of them raised their hand. I said, how many of you said, you know what? Wait a second. I need to talk to somebody that I believe is informed and talk to them about what are my options? What are the rules? You know, we're all people of rules. We'll play by the rules. We don't like the rules. We try to change them, right? What are the rules? What are my choices? If I do this, what happens, hypothetically, if I don't do this? You know how many of them raise their hand? Zero. I said, that's the problem right there. You guys have to ask the question, right? And all I did for the most part was helping educate them on the rules and let them make their own choices. And again, not one business owner was ever closed or attempted to be closed for not complying with an executive order. Now, there were about 5 to 6 businesses throughout the whole state that ended up having to close by a court because there was a local food ordinance that they weren't following. And so what it meant is that the local health department was trying to use their food ordinance to accomplish the policy objectives of the executive order. So the executive order said no indoor dining. That's not enforceable in any mechanism in the law. So they use their local food ordinance to say, well, if you have indoor dining, it's violating the provisions of the food ordinance. 5 to 6 in 4 counties. 102 counties, only 4 counties played that angle. The rest of them, they didn't, okay? So there's an analogy there to be dealt with as we're talking about school boards. And any of you ever thought why here we are now in almost September of 2021, and really the only conversations you're bombarded with right now are the schools and kids in masks? Have any of you thought why is that the conversation today? Because we talk about it in our firm all the time. And go ahead.
That's the only place that we have to speak.
Who has to speak?
The public, the parents. I mean, we have a platform to speak there, so we're taking it.
No, why do you think that the government is pointing at that institution and trying to compel this health guidance in that?
Control. I say small business owners aren't listening anymore.
What'd you say?
Small business owners aren't listening anymore, so they're forcing it onto the school.
Nobody else is listening, except they still have some ability to wield fear against these bodies of government, right? And I'm not here to criticize school boards as a whole, because I'm not in their position. But I think that the governor's office and the State Board of Health and the State Board of Education all have come to appreciate that nobody else is just following along without raising the questions that, again, I'm suggesting to you need to ask as a school board. You remember back last year and earlier in the year where we had this 8% positivity was the magic number of death as it related to the region and whether or not we would open indoor dining back up? Well, once we get below 8%, then we're going to go to phase 5. And once we're in phase 5, you can have indoor dining. But if we start going back over 8%, we might have to go back to phase 4. Do you guys realize that in region 4 in the Metro East, down to where I'm from, almost a month has gone by at over 10% positivity? Have you seen anything on the news that, oh my goodness, we're going to shut all these bars and restaurants? No, because you know what? They're not going to listen. And when this happened last November, overwhelmingly, most didn't listen. State police wrote a couple of tickets to my clients, and guess what? One of them got thrown out of court because there was you can't use law enforcement through some criminal ticket to enforce an executive order. The law doesn't even recognize it. Judge threw it out. The other ticket, the state's attorney didn't even enter into the system because he knew it wasn't anything. But you know what they were getting some effectiveness with all along? Fear, right? Fear. And I'm suggesting to you as we go through this right now, and I talk about asking these questions, it's for school districts to ask these questions. And if enough of you ask the questions that I'm going to lay out, it's over with, right? And that doesn't mean your school district may not choose to make a mask required policy. There is some authority in the law that says local school districts do have the discretion to put these policies in place if there's an actual identifiable emergency in the community based upon real numbers in your community, and you put temporary measures in place until that emergency's gone, then you got to let them drop off. Law's clear on that. You've always had that authority as local school districts. So I want to talk about, again, I've given you some documents, and I want to talk about, again, some of the overarching laws, and then I'm really going to drill into the rules and regulations, and I want you guys to see where these questions lie. How many of you know what JCAR did yesterday? Day before. Anybody? Sir, what did they do?
They sent a letter to the ISD asking how they have authority to do this.
Authority, they're asking the questions, right?
They're the legislative rulemaker for the Illinois General Assembly. So they finally maybe got, in my mind, it looked like maybe some of us got some attention to them.
Do you think they're sitting there going, oh, we see the questions that are being raised? Maybe we better start asking those questions, because if the public asks those questions and we know they're good questions, we don't want to be seen as having done nothing. Do you think that might be possible?
I think some of that, and they might want to have a little power of their own, a little bit. I think some of these agencies, nobody wants to be left out of the power struggle. I don't know. I hope they are on our side on it, but I hold out a little hope of that right now. Even Jake.
It'd be a novel idea that if the legislative branch of government would want to protect their branch of government, right? I mean, that's what this is about. So you're right with JCAR. JCAR is the Joint Committee of Administrative Rulemaking. It is some delegated senators and House of Representative members from each party, and they oversee the administrative rulemaking process, which I'll get into. Not only if you're going to pass rules, do they have to go through that if you have an administrative agency acting beyond the scope of those rules, they're going to step up and ask the questions. Because when the legislature makes the laws and they give life to these administrative agencies, these administrative bodies are created to further whatever purpose and policies that the legislature has created them for. So the Illinois State Board of Education was created to help run our educational system, and the legislature has given them by law certain authority and has restricted them by law in certain fashion. One of the things they can do as administrative bodies, they can make rules, because you have to be able to make rules to further the purpose of why you came to be, because otherwise you don't have the ability to operate. But these rules are very important, as they cannot exceed the authority that the legislature has given that governing body. So if the legislature says you can only do A, that's it. You can't create a rule for yourself that says, I'm going to do A and B. That part that says you can do B is invalid because it exceeds the scope of the law. And that's going to be important as we move forward. So one of the first things that I want to point out to you guys that you should look at is 105 ILCS 5/10-20. It's probably not in, I only gave you some of the citations in these documents. But I want to say that again, 105 ILCS, Illinois Compiled Statutes, 5/10-20. That 105 is that part of the Illinois Compiled Statutes that is the school code for you board members, and you're probably familiar with that. The Illinois School Code is about 1,350 pages long. You stack it up, it's about 10 inches tall. Okay, and there in the school code, it creates the State Board of Education as a body, administrative body. It also creates your local school boards and brings life to your local school boards, and it vests you as school boards with certain authority. And that authority is very broad because the concept is that you as local school board members are right there with your constituents, and you know what they want because you live amongst them, right? And it says under 5/10-20 that the school board has the powers enumerated in the sections of the article, which that means throughout 105. But it says this enumeration of power is not exclusive, which means that's not limited to those, but the board may exercise all other power, all power, not inconsistent with the act, which is the school code, that may be requisite or proper for the maintenance, operation, and development of the school and the school district. Guys, that's very broad power that you as local school districts have. Now, as I continue on, how many of you have heard of House Bill 2789? Right? I'm going to get to what some of the main amendments to the law that they were trying to make as we go on. One of them was right within this section, where they were trying to take that broad scope of authority and draw some of that back away from you. And we'll talk about that in a little bit. But I want you to keep in mind that that provision of the law is where your authority comes from, and it's very broad. Now let's talk about ISB for a second, because again, ISB, State Board of Education, I'll say ISB, they get their life from the legislature and the school code, and they are also given certain authority, right? One of the things that they get, which is under 105 ILCS 5/2-3.25. I need to repeat that. Everybody get it? Guess what that is? That's where the legislature says, ISB, we're going to give you the responsibility of creating standards. You guys have heard this word in the last 3 weeks, right? Standards. And it says that ISB gets to determine for all schools under the Act efficient and adequate standards for the physical plant, heating, lighting, ventilation, sanitation, safety, equipment, and it goes on. There's that word safety, right? What does that word mean? You know what? That's going to be part of what we're going to talk about. Does safety include that they can make and have in fact made rules and regulations about public health? Do public health rules, does it fall within safety as contemplated? That's a question, right? I'm going to show you that the answer is no, but at least that's a conversation to have. So when they say to create standards, that means they have to adopt those standards within Title 23 under the procedural requirements of the Illinois Administrative Code. They go through all these rules through JCAR, and they have to make sure that their rules don't exceed what they're allowed to do under the law, okay? So how many of you have heard of the Health, Life, and Safety Code, right? You guys have heard of the Health, Life, Safety Code, right? It's within Title 23, Part 180, right? So if you pull up Title 23, Part 180, it talks about that. And one of the documents that I had given to you, you're going to see here, Health, Life, Safety Annual Inspection. It's one of the sheets that you guys have. And when you get a chance, you go through that list. And again, this is just a checklist. It's not a rule or regulation. But what this is going to show you, once you drill into the rules of Part 180, there is nothing on this checklist that has anything to do with public health. Because the State Board of Education are not public health experts. The Department of Health is, but not the State Board of Education. You won't find it anywhere in there. But under Part 180 of the Health, Life, Safety Code, you have 180.10, which is the purpose and the scope of the Health, Life, Safety Code. Why is it being created? And it says it's to establish minimum standards for public school facilities. That's an important word because that's defined, which will protect the health, safety, and welfare of the kids. Okay, we're fine with that. See that word again, safety, coming up? And it says there further in Part 180, it says that all school districts in the public schools have to comply with this part of the code, and that's fine too. And then if you look at, again, Part 180 of Title 23, Section 180.40, what are the responsibilities of your local school board? What do you have to do? And it says you shall maintain and operate every facility in full and continuous compliance with the requirements of this part. Part 180, the Health Life Safety Code. You absolutely, as a local school district, are obligated to follow the Health Life Safety Code. No doubt about it whatsoever. And then again, under Part 181.60, it says that every facility, that word comes up a lot, facility has to conform to the standards identified in this section. So again, those standards within Part 180 of Health Life Safety, again, over and over, your school district has to follow that. So the questions that we're getting ready to talk about, very specifically, is with the law and the standards and rules as they exist today, not how they were trying to amend them under House Bill 2789. Do they compel you to have to comply with this state guidance? And if you don't, can ISB suspend your recognition status? That is the question, okay? And I've got a couple of recordings that I want you guys to listen to, because here's how House Bill 2789 works. And when I'm giving you this information, it's for the purpose of when you, and what we're working on as a team, which I'll give to you later, is what information do we have other than the plain reading of the language of the law and the rules? I think you'll be, when you read that, you're going to go, we know what it says, Tom, and we've got a huge question here. What were they trying to accomplish with all of these amendments that they were trying to make to the law? And you know what? If you listen to the committee meeting minutes, because House Member Mussman, Michelle Mussman, she proposed House Bill 2789. You know who the major proponent of that bill was? The Illinois Education Association was pushing that bill. And they brought that in front of the legislature. She's a Democrat, right, trying to make changes to the law. And I want you to listen to what Ms. Mussman said this is when she was making her final amendment that they wanted to pass out of the House and send it immediately to the Senate for the Senate's consideration. And she was trying to do that quickly because it was April and they're trying to get ready for the school year that we're in right now, okay?
This was a bill that we brought to you a couple of weeks ago. We were working with
Let me turn this up.
This was a bill that we brought to you a couple of weeks ago that we are working with a number of stakeholders on in recognition of the fact that the last year has been a little bumpy for schools, and many education-related advocates would like to see there being a little bit more clarity over what safe opening guidelines might be and an enforcement mechanism to make sure that those guidelines are in fact being enforced. We agreed to come back to the committee with an amendment. We do have an amendment that basically indicates that the Department of Public Health shall promulgate rules regarding the safe opening, and that the Department of Health would also be the main enforcement mechanism for those rules, and would have the ability to close down either a portion of a school or a school if they were found to be out of compliance. We have had some, as you imagine, that this has been challenging to come to the right agreements on what kind of words and mechanisms are the most appropriate. We had some last minute interaction with some of our advocates in the governor's office, and we are making it very clear that IDPH and ISB does have some recommended language, and that we will be adopting that when we get to the Senate. It would have been our intention to adopt it here tonight, but we were not able to get it out of LRB in time. So adopting this language is acceptable to the parties with the understanding that the bill will be further modified in the Senate. I want to make sure that that's set on record, that this is a good step, but it is not final action, and we appreciate that everyone has been willing to continue this conversation. I'm happy to answer questions, and I believe.
Okay, so before I go to the next one, Riley, you know how to turn that off. I messed it up last time.
We have 3 proponents. Donna Cusick with the Illinois Federation of Teachers, Sean Denny and Unique Morris with the Illinois Education Association. We have.
Okay, so there's a couple of things that you probably heard in there. One, they were trying to, at least at the point in time it was in the House, solely give rulemaking authority and enforcement to the Department of Health, right? That's where they started. And actually, when it came out of the House and went to the Senate, it only had language in there that says the Department of Health creates the rules, that they can enforce the rules, and they were modifying the law to say that you as a local school district have no authority to disregard those rules. That was in the House. And so I would say to you respectfully that if they were adding to the Illinois School Code a specific provision that says you were compelled to listen to that guidance, would they have done that if they already could compel you to listen to the guidance legally? It would be an exercise in futility. And did you also hear the part where she said, we've already agreed to make some further changes to this language because of the advocates from the governor's office? Did you hear that? Because IDPH and ISB had some concerns, and the governor was lobbying for them, and so those changes will be made in the Senate. Let me tell you what they talked about when they got to the Senate, because that bill passed the House and went to the Senate. And I would suggest to you they were in a hurry because they were trying to get this thing passed.
Surely not just clarifying the existing rule like our lawyers said.
I would tell you what, if someone wants to say they're clarifying an existing rule, the legislature, did they say that? Right? When you're clarifying an existing rule, we know what that means. And you're actually clearing up language that you say, go get this language here. See, you read this, it's kind of vague. We're making it clear. If an attorney says they're clarifying an existing rule, show me where it is where it's ambiguous. Like, point it out to me, right? Because when they were in the House adding the provision that you had to listen, that's brand new language. It's express and it's new. Show me what they were then clearing up. Because sometimes you do have legislative act that says, and usually when that happens, sir, is where you have some language that a court has said, this is ambiguous, and so we're interpreting what the intent of the legislature was. And the legislature says, well, that's not what we meant. So they'll come and they'll do a new law that clarifies an ambiguity that the court has said is ambiguous. Does that make sense? But this never happened. And this language that's being added is so crystal clear and so like spot on point that you would have to ask somebody, ask your lawyer, please underline for me, I'll get to you, sir, underline to me in the law right now what is ambiguous that would otherwise give them the authority that they're trying to clarify. You watch them stutter if you ask that question. Yes, sir?
Not sort of the discussion that,
Yeah.
it's not just that, but I think all the lawyers are saying the exact same thing.
Do you think that's coincidence?
They're getting their check paid by the governor.
Do you think that, and again, I'm not here with my colleagues to say anything about them whatsoever. I would never do that. I would just say this to you as critical thinkers. Do you think it's a coincidence that from the northern part of our state to Cairo, the exact same message has been given to every school district? I just came from Florida, Illinois last night, which is 4 or 5 hours south of here. It's down south of Mount Vernon. I had that same question because you know what? The advice they're getting down there is exactly the same. And I politely say, our firm, I'm a litigator. I go fight in the courtroom. I have a lot of transactional lawyers in our firm. We represent a lot of lending institutions. If I'm asked a question and I have to give advice right down the middle that our main client base could see as problematic, I'm in a tough spot. And so I would choose to not answer. But there's a lot of school districts that don't agree with you guys, right? They think you ought to just fall in line. So do you think if you get advice, like I'm going to, not giving you advice, but I'm giving you both sides of the conversation, do you think you might be concerned about alienating some of your client base if you do that? I mean, because that answer that you're getting right there is poor, in my opinion. Because they should be able to tell you, if I gave that advice, going, they're clarifying language from an ambiguous interpretation, okay, show me that provision that was ambiguous. Don't just tell me they're clarifying prior ambiguous language. Show it to me, right? Because I'm going to tell you that's nonsense. So we get into, now they're in the Senate. And Senator Belt from East St. Louis is proposing Senate Amendment number 1. You listen to this, keeping in mind when he is speaking, he's saying what the purpose of this bill is. Now, when you heard Senator Mussman talking before, did you hear her say, look, we've got some language that the court's interpreted in a way that we don't think is proper, we're going to clarify? If they were clarifying prior language, they would be saying it in these meetings, okay? Let's listen to what Senator Belt had to say when he presents Senate Amendment number 1.
Senator, before you begin, let me look at your witness slips. House Bill 2789, Senator Belt. And Senator, before you begin, let me look at your witness slips. You have 132 proponents, 16,418 opponents, 73 no position. Senator, go ahead and explain that. Oh, we have the other amendment. Senator Cunningham moves to adopt Senate Committee Amendment 1 to House Bill 2789. Is there leave to adopt the amendment? Leave being granted. Senator, go ahead and present your bill.
Thank you, Madam Chair. House Bill 2789, as amended, provides that the State Board of Education must adopt rules to address schools and education license holders who do not comply with public health requirements established by the Department of Public Health when the governor has declared an emergency. Additionally, the bill provides a complaint procedure to report schools that do not comply with the requirements when the governor has declared an emergency. Lastly, the bill states that for non-public school recognition, they must provide assurance that they will comply with these health requirements when the governor has declared an emergency. Madam Chair, this bill it's triggered whenever the governor has declared a state of emergency. Once a state of emergency has been declared, the IDPH sets the parameters and the metrics for school districts during the time of the emergency. No different, and those parameters will be consistent with the CDC. No different than what we do right now. What the amendment did, it's also brought in a complaint procedure. So say for instance, in this pandemic, if you go to school XYZ.
Before I continue, how many of you, when you got letter number 1, says we've received a complaint that your school's not in compliance? Did you hear that we're going to create procedures? It's a complaint process. Do you believe there's a fair question to be asked of whether they're utilizing procedures of compliance that were being proposed in this law but not yet adopted, but they're utilizing them anyway? They're using the same language. Okay, go ahead.
And you see 2 or 3 faculty members not, in the case of COVID, not wearing a mask. It says then that you can follow these steps to file a complaint to your local health department. Your local health department then will come down to look at the situation and see if the situation can be remedied, whatever that may be. And whether it's closing of a classroom, whether it's just putting back on your mask and remedying that whole situation. Finally, it authorizes ISD to be able to enforce the rules up to the point of non-recognition for those schools who don't comply with the parameters set by the IDPH.
Did you get that last sentence? Did he say anywhere in there that we're clarifying that ISB certainly has the authority? It says we're creating it, right? So that's the answer to that. And if there's an opinion out there that says, well, they could be just clarifying otherwise ambiguous language, you don't hear any of that in here. And moreover, show me the language in the law that's ambiguous that they're trying to clarify. It's not in there, I assure you. Because if that was true, do you think JCAR would be asking the questions they're asking right now, right? And if you listen to this Senate hearing committee meeting minutes of Senator Bell, it's an hour long. There's a little buffering going on. Now, when I called the Senate, said I need these minutes. Oh, we don't record those committee meetings. I don't know if they do or don't, but I do know that an hour after I asked Senator Bailey if he could get a hold of them, he had them in my email. This particular meeting was an hour long, and it is crystal clear. Senator Bell, while I disagree with his policy of what he was trying to accomplish, he was crystal clear on what he thought was in the best interest of this state. where they were going to, during the times of an emergency, and let's accept that we're in one, that they were going to centralize the power of this public health stuff to the State Department of Health and going to compel you as local school districts to listen. And if you didn't listen, your recognition status could be attacked by ISB. It was absolutely crystal clear that that was what he was trying to say was the best policy decisions for our state. While I disagree, the man didn't hide the ball. He wasn't pretending to try to hide it. He wasn't saying anywhere in that hour-long meeting, well, ISB already has this authority, but we're just trying to make it clear. I mean, that's absurd. Nothing. They were trying to create new law and new procedures that I'm going to lay out for you. Now, I haven't gotten the answers yet, but I sent FOIA requests to the Illinois State Board of Education, to the Senate, to the House, for every email that's been back and forth and every document between all of these agencies and the Illinois Education Association regarding this bill, because I want to see the emails in there where they're talking about, we got to get this law passed so we got some teeth, right? It's no coincidence that, again, I don't agree with Governor Pritzker's policies, but he was trying to use his influence with his departments to get this bill amended in such a way that they had the teeth in that enforcement mechanism. Otherwise, they're sitting there with a hollow mandate with no ability to enforce it. And that's what they didn't want. That's what Senator Belt said they were trying to remedy with this. But what happened, guys, is you, and I'm saying you as people of the state, there was a supermajority. If that's what they felt was best, they could have passed it. How many times have you ever seen a bill get crushed in the Senate and stalled where they didn't have enough votes to pass it to get it to the governor's desk? Do you hear 16,400 witness slips in opposition? That never happens. But that's why once that bill stalled, then they were in a position of what are we going to do? And so what they're doing is they have, again, I'm going to say to you this ruse, and I'm going to show how you ask the questions, okay? Before I get to the actual existing rules, I'm going to point out some of these amendments that House Bill 2789 was trying to make, okay? And I've got them here, and you guys can get this I can email you this presentation. But one of the amendments is that the administrative code was going to be amended to where the Department of Health would establish rules for this public health guidance during these times. Lay out the metrics. I mean, they've kind of done that anyway, right? They've done it in trying to force it upon the school districts. But this was the formal adoption of you actually can create rules. Because if the legislature doesn't tell you you can do it, you can't create rules about whatever you want. This would have been actual rulemaking authority. Then the House, before it made it to the Senate, was making a change to the Illinois School Code. I'm going to read it to you. 105 ILCS 5/22-92 was a brand new provision, sir. It wasn't modification of an existing provision, making clarifying. This is brand new. And it even says new in the proposed bill. And it says here, in order to provide in-person instruction, non-public and public schools must follow the requirements adopted by rule by the Department of Health regarding this health state mandate. You must follow it. They were adding that to the school code. And I'd suggest to you, would they have done that if you already had to follow it? It's not even logical. Then there was another amendment to a House bill rule where they were changing the administrative code for school districts. They were adding a provision that gave ISB the authority to adopt emergency rules to enforce this stuff. Brand new rule. And it was it's subsection RR. And again, you can get to those administrative rules. If you pull up the Senate amendment to House Bill 2789 and look at the underlined provisions, it'll show you what they are. And they were trying to give them emergency rulemaking. They were also trying to add new powers within the law that says what? The State Board of Education shall adopt rules to revoke recognition status pursuant to subsection A, which is the standards that we talked about, that do not comply with public health requirements established by the Department of Health when the governor's proclaimed an emergency. That was a brand new legislative provision being sought to be added that says the State Board of Education can create those rules to compel you to comply. Then, remember the powers of the school board, section 10-20 that I told you about a while ago, where it says that you have not, it's not exclusive, but you may have all power for the maintenance, operation, development of your school board. Under section 10-20, 105 ILCS 5-10-20, guess what? They were trying to add a specific another sentence to the end of your powers, and I'm going to read it to you. When the governor has declared a disaster due to a public health emergency pursuant to Section 7 of the Illinois Emergency Management Agency Act, a school board may not pass any resolution that is in contravention of any requirement established by the Department of Health. They were specifically adding into those powers a limitation that right now today you would not be able to do that. And if this had become law, I would stand here in front of you telling you, you don't have a choice. This is not law. And again, I'm going to keep coming back to you, sir, because I know that's what school board lawyers are saying. What prior ambiguous language is that attempting to correct? It doesn't even make any sense. There's another one that you guys have heard about teachers. Oh, our teachers or our superintendents, their licensure could be at risk if they don't require compliance. You guys heard this one?
Yeah.
Guess what? They were trying to add into the law in House Bill 2789, take any action to sanction an educator or individual licensed under the code who implements any practice that's in contravention of any public health requirement established by the Department of Health when the governor has declared a disaster due to a public health emergency. They were trying to add that provision to the law to penalize educators or administrators for not following this guidance. Not only was that horrible policy, which probably means why it just got destroyed in the Senate, they haven't added that in there. So if they're going to try to sanction a teacher, please explain to me what provision in the law or the code right now gives you that ability. They don't have one.
Can I stop you?
Sure.
Wild rumor now is that there was some way to affect teacher retirement system.
Part of that is my understanding is that if you as a teacher actually have your licensure revoked, that can have an implication on your retirement benefits, etc. I've not studied that, but I understand that there's a nexus between that. But again, that threat that scares people, you have to jump back and say, well, first of all, tell me how you can suspend my licensure because I'm not forcing children in a classroom to wear, is that what they're trying to accomplish,
That's
right?
only if you're in non-recognized.
Yes, if you're not teaching in a recognized accredited school, then it does not go towards your TRS.
Understood, yeah. So
10 days, you got to teach 10 days of the non-recognized status to lose your TRS.
So the game there is if teachers would then use their political influence, which they have, to force you as school board members to not stand up, because if you become non-recognized, this affects us, right? But they still, when they do all of that stuff, guys, what are they not doing, ladies? They're not ever talking to you about their ability to put you in that status, which is, we're getting to the nuts and bolts of that. Remember when I told you a while ago that the Hudsonville case up there, where they went to court asking Judge Grishow to use her power of the court to compel Hudsonville and 2 private schools to follow the health department's mask guidance, because they said, and I read to you, the plaintiffs have no adequate remedy at law. What that means in English is, unless you, judge, tell them to listen, we don't have a way to make them listen. Now here they are telling you guys in your threat letters, we got a way to make you listen.
Can you read that again? Yeah.
The plaintiffs have no adequate remedy at law. Because when you go to court, guys, and you should ask, I talked to a couple of superintendents that are now pushing back on their school board lawyers saying, why don't you answer that question? Because if that case back then, not only is it not precedent that you have to follow, a judge could rule differently of whether he would use his power or hers. You have to go into a court of equity saying, I need the court to come wield its power. You have to acknowledge to the court that you don't have anything in the law to get that accomplished. Otherwise a court cannot use its power unless you don't have anything on your own, because courts don't get into controversies like that unless somebody comes there saying, we're desperate, we need your help. And that's what they did last year. Plaintiffs have no adequate remedy at law. That included the State Board of Education. You know what the remedy of potential recognition status is? That's a remedy at law, because the law, the language in the legislature and the rules they're saying right now when they send you these probation letters that we have that lawful authority within these documents. What that says right there in last year was inconsistent with that. And again, I don't think that that in and of itself controls your decision making, because again, a judge could just say, I'm not giving you an injunction. Have you seen the governor's office on the 30-some schools that we know of that have chosen to do this? Have you seen him go to court like he did against those three last year yet and say, Judge, give us an injunction? Anybody want a reason on why they think that's not happened yet? Do you think the optics of this issue are the same now as they were in August, right? You know, courts are human beings just like all of us. None of us are perfect in any human being, whether we're in government, not in government, judicial system, we're all human, we're all flawed, we all are sensitive to the communities around us, right? Nobody wants to be at the epicenter of that. Our legislature certainly doesn't want to be at the epicenter of it. The governor conveniently put you school board members at the epicenter of it instead of taking that himself. But yeah, so they've not went to court. You'd ask your school lawyer, well, why didn't they take us to court like they did Hudsonville last year and try to get an injunction against us, right? I know the answer and won't go down that path. But that path contradicts this path. You can't have it both ways. You either have a remedy or you don't have a remedy.
They also didn't go down the path of non-recognition status at that point, did they?
Exactly. Why not? They should have, if they truly believe that that's always been an option for them, then they mischaracterized their position to the court last year. If they would have last year sent letters of probation, at least their positions would have been consistent. I still would be of the opinion they didn't have that authority last year. But if they believe that they do, they should have done it last year. They didn't. See how they're flip-flopping and kind of jumping around? Now let's get to the fun stuff. Your recognition status. How many of you in here understand, because I tell you until 3 weeks ago when I spent, 100 hours doing this and talking to some superintendents, you all understand the recognition status, compliance, familiar? Anybody? Any of you as school board members have to deal with it? Yeah. You, sir? Okay. So every year, your school district has to apply for making sure that you're in compliance with what? The standards. And so you can get your good standing, because that's important. If you're during the summer, your building falls in, or the roof caves, or your air conditioner goes out, or there's some issue, your recognition could be, again, maybe put on probation, etc. Because you got to fix that, because it could be a problem for children, safety, right? And so by September 30th of each year, you have to submit an application to who? Anybody know who you submit that to? The regional office, whoever your regional superintendent is. And the annual inspection checklist here is one of the documents that you're having to make sure you're good with. And when you have a chance, as I told you, go through that document. It deals with, occupancy loads, number of exits, emergency lighting, and then you get into automotive shop. Is your fire rating good? Is your electrical good? All of this stuff, every page of it deals with facility-related issues, okay? You will find nothing in here that you've ever had to file and say the public health stuff is up to shape. It's not in your recognition standards, okay? So you have to file that by September 30th to your regional superintendent. And then when she gets it, anybody know what the next step is? She's got 2 weeks to go through that, do any kind of review she wants, and she submits that documentation along with her recommendation to, who do I send it to? State superintendent, not the board, state superintendent, okay? And again, that's today, that's Dr. Ayala. So she will get sometime around October 15th your application with a recommendation from your regional, okay? Now, keeping in mind, once your regional superintendent does that, she still has obligations throughout the year to make sure that you're still operating a safe school and you're in compliance with what? The Health Life Safety Code, Part 180. And if you're not, we'll get to what she would have to do, okay? So Dr. Ayala gets this information. Now, the part that I just read to you guys, and I've given you the sheet, and if you could, we'll follow along here. I've given you section 1.20, the operational requirements. This is one of the most important documents. And you see, I just read to you part 1.2a, where it talks about, even at the top, your district's recognition status is based upon compliance with the requirements imposed by law, law being the Illinois School Code, including but not limited to the recognition standards established by the state board under section 2-3.25. 2-3.25 is that part of the law that we talked about earlier that says they have to create these standards, okay? So you have to be in compliance with those standards. Then under part 1 that I told you, under 120A1, is where you have to submit that to the regional by September 30th. Then part 2 is where by 2 weeks later, the regional has to send it to the state superintendent. And then we go to part B. This is where this gets good, because when I'm talking to you guys about and what is going to be having to answer either 1 to the JCAR committee or 2 to the court, which we'll talk about in a little while, go to part B on page 2 at the top. And I've got it underlined for you. Based upon the information provided by the district and the regional superintendent, the state superintendent, that's important, shall assign a recognition status for each school and for each district as a whole. You see that? And if you continue on, it's not underlined, but you see she has to post that on the state's website. If you go to the state's website right now, do you think any of you have recognition status of probation actually published? It's not. No, it's not even there. Okay? But again, there's a reason for that, sir. We'll get to that. Do you see where it says, based upon the information provided by the district and the regional superintendent, the state superintendent shall assign a recognition status? You with me? So her being able to assign your recognition status is predicated on this annual compliance process that you're a part of every year, where you submit it to the regional sends it to her, then she can assign status. Now let's jump down there under subpart B, under provision number 1. I have it underlined. Each school or district that meets the requirements imposed by law, including the requirements under 2-3.25, which are the standards, shall be fully recognized. And what that means is that Dr. Ayala has no discretion to do anything during this annual compliance process other than make you recognize if you've satisfied these requirements that are actually requirements that are in the law and the rules. She just can't find something, she doesn't like the color of your roof or something. It has to be drilled down in there. Let's go to the next part. Because if you've got the letter, and I'm going to go ahead and jump out, I've given you guys a copy of a letter that's your probation letter. Some of you've got this, I think. The other schools, it's a carbon copy. It's the exact same document. And before I go to this next step in the code, I want you to read the first paragraph of that letter from the State Board of Education. The first paragraph says, the staff has verified that you're not compliant with the universal masking requirement of the executive order, right? Therefore, effective of this date, the recognition status of the school is on probation for exhibiting deficiencies that present a health hazard or danger to students or staff. And it cites that section. You see that? So what she's trying to say, Dr. Ayala, is that there's a universal masking requirement of the governor, and that since you're not following it, that is a deficiency that presents a health hazard or danger to students or staff. You with me on that? And if someone stops their analysis right there and says you have to comply, that is the most inappropriate analysis and a complete miscarriage of actually being honest with people, because it's completely unrelated, and let me help you. Now going back to the law that we had, and you see here under subpart 2, where Dr. Ayala, a school district shall be placed on probation if it exhibits deficiencies that present a health hazard or a danger to students or staff. See where it's underlined? Deficiencies in what? Anybody know what deficiencies the rule's talking about? Yes, deficiencies in the standards, right? Not some deficiency that somebody might think is deficient. It has be deficiencies in the standards that are promulgated in the rule, which as it relates to safety, Part 180 of the Health Life Safety Code, okay? But let's stop there for a second. That's a substantive issue. That's dealing with the substance of whether or not following a universal mandate rises to the level of a deficiency as defined in the rules. That's substance. Let's set that aside. Let's talk about procedure. When is Dr. Ayala herself, as the state superintendent, making that decision? Procedurally, when is she called on by rule to make that decision? Anytime during the year?
It's the annual assessment period.
Yes, sir. Thank you. It's the annual assessment period where she is delegated by rule the ability to put you on probation potentially if you are exhibiting a real deficiency. But we're not talking about deficiency yet. Procedurally, that's when she gets to call the ball. Now drop down to section C that I got underlined. You ready? The recognition status of a district or school may be changed by who? The State Board of Education at any time to reflect information confirmed during compliance monitoring. Compliance monitoring, as I told you, your regional superintendent has to do all year long. The State Board of Education has, by rule, the ability to put you on probation at any time during the year if there's a deficiency. We'll get to that. The state superintendent's authority of putting you on probation is limited by the clear rule to this annual compliance review. So when she sent you guys a letter in August of 2021, is that during the annual compliance review? No. She doesn't even have the delegated power by State Board of Education to send you that letter at this point in time. Has anybody told you that yet? Anybody? Right? Whether you say, Tom, we understand that crystal clear, and we believe we're more likely than not, that interpretation makes sense. Do you think school boards ought to be asking that question? Right? Yes, sir.
Are school boards hired completely moronic lawyers?
I'm not going to.
I'm serious. Are they hiring the biggest goddamn idiots in the country?
I am not. I'll let you guys draw that conclusion for yourself. I have nothing to say about people, right? And I grew up on a trailer park, you guys. So I am the most humble person you'll ever meet. But the analysis that I'm doing is I do not know a lawyer that disagrees with what I'm telling you right now. I personally do not know one. So when I've talked to superintendents that have said, ask this question to a school board lawyer, ask him this question, you know what? They're not getting an answer back. Now, I'm not saying anybody's dishonest. I'm not saying anybody's stupid. I'm just saying that sometimes when you're going to answer a question that might create strife at a greater scale, you get, because I'm going to say this respectfully, you have the Illinois State Board of Education, you have the governor's office, you have the Illinois Education Association, you have the lobbyists for all of these businesses, you've got the conventions they go to, the seminars they go to, and the school firms are a part of that whole structure. And they have a message right now that's cohesive across the state. Who's going to step outside that group and tell you what I'm telling you, right? Nobody. And what I'm saying to you is, you don't have to walk out this door saying we 100% agree with Tom. But I would ask you to walk out this door saying, before we're going to yield our local discretion of how we're going to operate our school, somebody better answer that question. Somebody answer it, right? And we'll talk about that in a second. But do you see by rule that according to this breakdown, that the state superintendent is limited to the annual compliance process, and she doesn't have the discretion any time of the year she wants. And there's reason for that, you guys. Boards, when you say the word board, school board, state board, that is comprised of multiple people. And that is a deliberative group of people. You school board members here, you probably got people on your board that maybe don't agree with you. And that's okay, you deliberate. But just think, sir, if they made you sole decision maker of the school board. But think about that. Think about that inappropriateness of that. That's why Dr. Ayala, as the superintendent, does not get to wield this discretion all year long, because you don't put that kind of authority in one person's hand. You put it in the board's hand.
That's why we vote legislators in too.
Exactly. So the State Board of Education, if they wanted to put you on probation right now for some alleged deficiency, I would say to you procedurally, they might be able to do that, but we'll get to that in a second.
Hey, Tom,
Yes, sir.
you're on procedure now, maybe this is a substance question.
Yeah.
How do I link section 120B2A to part 180? You expressed it. How do I make that connection?
Well, again, when you're talking about deficiencies, right, you have to say deficiencies in what? The deficiencies will be grounded in what are the deficiencies in the application process? What information are you providing that you have to be in compliance with? You know what I'm saying? And if you could find anywhere in the rules something related to safety that you could tie to an executive order, then there may be a substantive link. But right now, and I'm going to get to it, there is nothing in the rules anywhere, not even just in Part 180, anywhere in Title 23 that says you as a local school district have to yield your legislatively delegated authority to an executive order, and if you don't do that, your recognition status could be subjected to penalty. It's not in here anywhere, okay? So when you're saying deficiencies, substantively, it has to be a deficiency in something that you're required to comply with, right? What are you required to comply with? Take the whole Title 23. Again, I talk about Part 180, sir, because it's health, life, safety. You can take all of Title 23, which has all kinds of standards, because the standards that you have to follow are not limited to safety, education, curriculum, all of those types of things are standards you have to comply with. None of them, you cannot remotely find one that could ever be construed to say state level guidance from the Department of Health or the governor is a element that you have to comply with in order to get recognition status. If they want to try to take you to court and get Judge Grishow to enter an injunction saying you have to comply, that's a different legal conversation. What we're talking about is your recognition status at risk for not complying? That's a completely separate analysis, and it has nothing to do with the governor's executive order. This argument that we're having here, a debate, governor's not even in the race. This is ISB and you. And can ISB, under these rules, mandate that you follow that executive order? My opinion, professional opinion, is no. All I'm asking you to consider, there's a big enough question here that we're going to go ask it, right? And part of what I've done, and I'm jumping ahead, there's an 8-page letter that I've given you guys that I drafted for a school board, right? 8 pages, and it's directed to Dr. Matthias, I think, that says, we got your probation letter, and you know what? Before we start talking about whether or not we're going to provide a corrective action plan, we got some questions, and they're threshold questions. Before you take us down that path, you're going to answer procedurally, does Dr. Ayala right now today, by rule, have the authority to do this? And then we're going to get to the substantive part here in a second. It raises those questions in here and asks them for a meeting with the State Board of Education, not Dr. Ayala, says we need to have a little talk, okay? And that they may stonewall you, and we'll talk about that in a little bit.
Sir,
Yes, sir.
has anyone seen the video of Dr. Ezekiel talking about this virus when it first came out?
Go ahead, sir. I mean, she's talked a lot, but if you got something to say, go ahead.
Well, she's talking about how they falsified death certificates on these deaths. This is an attack on everybody.
They could be, you know, again, I don't, let me tell you this, I don't go down the path of falsification, but I will tell you this. If you guys get into the conversations, which is really beyond the scope of this, about, you know, the risks of this virus, are you guys aware that only 1 out of every 4.2 cases is ever reported to the public health bodies? 1 out of every 4.2. So if you are going to calculate positivity or mortality, you can't do that solely based upon the positive cases that have been reported. You have to do that based upon the CDC estimates, because again, they are certainly an authority we can consider. We don't have to listen to them, but they give evidence that's good. If only 23% of the cases are getting reported, the mortality rate of kids under 20 is so close to 0. Guys, it's 0. It is absolute 0, as close as you can get. And even for people over the age of 20. if you add in the estimate of only 1 out of every 4.2 is being reported, it brings the statistics of COVID not much different than the annual flu. But again, I'm not here to have that conversation. Again, my limit.
I should listen to that video though. She specifically said it.
She said a lot of things over time,
Play that video.
but I certainly.
That's what we need to be talking about.
Well, again, that's not for today, sir. Let me go on here. So we've talked about the part where, again, under the part 1.2C, the State Board of Education can procedurally at any time, okay? But how does the State Board of Education get to the point where they might potentially suspend or put you on probation during the outside the annual compliance provision? Remember when I told you that the regional superintendent has an obligation to do ongoing compliance? Well, guess what? We've got section 400 of part 180, and I've given you a couple of those sections. I've given you part 400 and I think part 410, okay? And if you go to part 400, it says at the top, if the regional superintendent determines that in a facility, right? You see where it says that a facility, they're always, when in regard to safety, you're talking about your buildings and your structures and your ventilation and your electrical, fire suppression. The word facility is specific. If it doesn't comply with the provisions of this part being part 180, which is the health, life, safety.
We got 425-30.
Yeah, he's probably just meeting over here.
Oh, okay.
You need a 400, sir? So the regional superintendent has a duty by rule, and it's proper, to keep track of what's going on in her region. And if you have some issue of non-compliance with the provision of health, life, safety code, she has some things that she has to do. She can order your building inspected. Who inspects it? Some hazmat? No. A licensed designing professional, because you're dealing with, again, the facility. And Part B of Part 180.400 says if the regional superintendent can serve a notice of violation on you, right? That says that you are violating some specific thing that needs to be corrected in the health, life, safety. And then once you get that letter from her during the year, you've got 15 days to respond to the superintendent and to her saying, you know what? This is not applicable to us. Doesn't apply. It's outside your scope, and we want to have a little talk about that. That's how, during the year, outside of annual compliance, any alleged violations of the health, life, safety code are addressed. They're addressed through your regional, not from getting some letter from Dr. Ayala trying to place you on probation for something that's outside her scope of the rulemaking authority. So let's talk about what are the types of things that your regional superintendent might have a concern with, right? Why would she maybe come and be talking to you about this?
Air conditioner not working.
It just came on, thank goodness. So I've given you part 180.410, which lists the types of unsafe conditions that the regional might be looking for that could be a problem that affect your recognition status. Now, this is not an exhaustive list, but it's important for a couple of reasons. If you read the list of 10 types of things that the regional might be concerned about, conditions that might contribute to a spread of a fire, conditions which interfere with the efficiency or operation of fire suppression equipment, fire escape, stairways, passageways, doors, windows, dust, debris, grease in the kitchen, hazardous conditions affecting the wiring, the equipment. Do you guys see what type of stuff that is, right? Is there anything in there that remotely talks about public health issues? No, because it's outside the scope of what your recognition status is dependent upon. And guess what? You know what House Bill 2789 was trying to do? Change all of that and put that burden on you by rule. Again, these rules I'm telling you now would have all been altered and would have all placed affirmative duties on you to follow this guidance. And if you didn't, you could be subjected to non-recognition issues. Okay, so that's the issue that we're dealing with now with public schools. I've got a little bit for private in here. I don't know if there are any private school people in here. Okay, I'll get you. But on the public schools, that 8-page document I've given to you, 2 problems. Procedurally, Dr. Ayala is outside her bounds except for the annual compliance provisions. And again, I'm just interpreting the rules. And if somebody wants to tell you otherwise, make them go through what I just did with you. Show me in the rules. Don't just tell me. That's what you'll get, right? Well, we're just clarifying the law. Really? Show me where. Outside the rules. Substantively, there is nothing in these rules as they're written today that puts the burden on you to have to follow this public health guidance from anybody, right? If the governor thinks his executive order is enforceable, if some lawyer wants to tell you that, hey, the governor can write executive orders, he can write them. The question is how can you enforce them under specific circumstances? And if they think there's a remedy that they can force that on your school district, tell them to come up with something else, because recognition status is not going to get you there because it's not in there. And if you don't think that that's what JCAR is asking ISB right now, you're fooling yourself. That's exactly what they're asking them right now. Everything that we've talked about here today is what they're asking. Yes, sir.
Quick twist.
Yeah.
I won't say what school, but OSHA violation.
Right.
Just came down.
I'm hearing about that, and again, that's well beyond this conversation. But I had a couple of times with businesses last year where OSHA thought they were going to start playing a game. I've not analyzed it yet with school districts, but it's the same conversations that we're having right now dealing with them. You know what? If I were you guys, again, you'd have to look at that and get somebody that's going to lay it out to you straight. But I'm not concerned about that.
They're referring back to ISB though.
Sure they will. The federal government doesn't want any part of this.
Okay.
You guys think it's a coincidence that everything you read at the federal level is all recommending things, right? Pretty much. Except for when you're traveling interstate commerce. If you get on a bus and drive from here to Indiana, the federal government can have some ability. And I think right now they say that if you're on a bus, you have to wear a mask. Now, we're not going to get into that. But if you read that order that's actually put out by the Surgeon General of the federal government, it specifically says in that order that it only applies under 2 circumstances. International travel on public transportation or interstate travel, because it's a federal jurisdictional thing. If you put your children on a bus in your school district and you travel to Missouri, I would tell you that that order applies. If you're putting them on a bus, or what county are we in here? Knox. If you put them on a bus in Knox County, the federal government doesn't have jurisdiction over that. And they actually say that in their order. It says in there expressly that this order is limited to this. And if you go read it, you got anybody telling you that? No, I'm not saying you put masks on your kids in a bus or not. I don't care. I'm just saying that order doesn't apply, and nobody tells you that. Yes, sir.
JCAR? You're talking about JCAR?
Joint Committee of Administrative Rules. Yes, sir.
They're talking with ISB right now. How soon can we expect some results from that conversation?
No time soon, I wouldn't suspect. I'm surprised.
There's a lawyer involved, right?
There'll be no time soon.
I didn't become one until I was 40. Don't give me 200. But those are the questions, and I'll get to more about those. But those questions, guys, you have to decide as a local governing body. What are you going to do? For you that are recommended now, you've really got 2 choices: put the mask back on the kids, or stand up and ask the questions, right? Because there's not going to be a lady last night said, "Well, Tom, we're gonna have a meeting with ISB," and I said, "Yeah." I said, "Okay." She said, "Well, how do you think that's going to go?" I said, "Well, I don't know, but if I was advising ISB and they were coming to talk to you, I would say the only thing you're talking about is how are you going to get in compliance. I'm not going to get into a conversation with you about our rule or substantive authority. I would tell my client, go down that path. You got the power, and if they don't think you have it, then they're going to have to push. It's like playing a game of chicken, right? So to me, school districts got to say, for their own good reasons, we're going to stand up and ask the questions, or we're going to go and comply so we don't have to get into that fight. And I'm not here to say which is the best. Yes, ma'am.
So I homeschooled for a while, and I'm not an accredited school. I'm not recognized by the state. I know my child's still going to go to college. I know she's still going to get scholarships. Who cares if we're recognized or accredited? I mean, my question is, maybe some colleges might care, but there's gonna be plenty that don't, so why do we really care? Is this really that big a deal?
Sports.
Okay, so the sports kids.
The Illinois High School Association is supposed to be an independent private entity, but they are extremely political and get dragged into the mess. But there's a provision in that, being an association, they have bylaws. It's almost like a governing document. And if they want to change those bylaws, you have to vote with the members. But there's provisions in there that say that your school has to be recognized in order for the kids to participate in sports. Keep in mind, guys, there's nothing wrong with that, because you see all the issues we're talking about here with being non-recognized. If your buildings are a risk, you wouldn't want kids in there, right? You wouldn't want them in there. So IHSA rightfully has that in there. But again, they're trying to now use it as a threat of intimidation where your kids can't play sports. And as lawyers, especially the good ones, when you have a conversation that you don't want to have, you know what you do? You redirect the conversation to someplace else because you don't want to have that conversation. So when they're saying, oh, what about yes, ma'am, Mary, what about the sports? Or what about funding? Well, you know what? All of that's predicated on, can you revoke my recognition status? Come on back, let's talk about that. Oh, your liability is, no, we don't care. That's not the conversation. Come on back to this. They will try to redirect you from the exact things we're talking about. School, sports is one of them. Yes, ma'am.
So follow-up question, let's say one district gets together with another district that's not accredited. I mean, who's gonna come and stop us from playing sports?
Nobody.
Okay, so we're still gonna play sports, right?
Yeah, I mean, you may have school districts that say, oh, you're still recommended on that.
They're trying to stop that too. It's when you get into postseason, because you can play your games all throughout the year. It's when it really comes into, when you get to be non-recognized. If it's in the regular season, it goes to a no contest.
Well, if you become non-recognized, like if you're getting into this ISB argument, doing nothing is a bad idea, right? Because if you get into non-recognized status, that can cause all kinds of issues legitimately. Because if you become non-recognized, you can't really then go back and say, well, it was all for wrong, because you got to start that argument now while the clock is ticking. So if you're not, but they're even beyond that, man. There's school districts down in our area that said, because we've got a lot of school districts in the South that are recommended, and the schools that are decided to be required, because it's interesting, a week prior they were recommended. Now all of a sudden, oh, we got to be required, and nothing changed. So it's illogical, but they call the school district and say, oh, since you're still recommended, we're not going to come and play sports with you, and you can't have the kid. It becomes a political quagmire. It does. And so how that affects local school districts here, that if you stay recommended, there may be schools in your area that are not going to let your kids play. That's a political issue that you guys have to deal with, which is completely beyond this issue of recognition status.
You didn't have to do with whether you recommend or not. It's basically whether you want to comply with the masking requirements. That's really all it had to do with. So we're still on probation. You can still go play, or we can have people into our gym, for volleyball, but we're going to say, when you come here, you don't have to wear your mask. That's what ours is saying. But if we go to their gym and they are mask mandate, then we would absolutely comply. We would respect their decision, just like they would respect ours or our choice.
I agree with you. And actually and that's a good differentiation. There was actually one down there that told the school, since your mask recommended, we're not even going to play you.
Yeah.
Right? And again, that political pressure, I mean, how a school district responds to that, I mean, that's, well outside of what I'm talking about. But it's a reality. And again, but what I can sense is, I've talked to school board members from the north and the south, and they pretty much address for themselves this, and again, it's not part of my presentation, the school district board member could get sued personally. And I just start laughing, going, why don't you ask them how many times it's ever happened? Ever? Show me a case in Illinois where a school board member's personal assets were taken away from him because he made a policy decision like this. Show me one. It's not out there. But again, that's beyond those other type of pressure points, from my experience, fatal in comparison to this, my recognition status, which could affect funding if you were ever revoked. That seems to be the biggest pressure point. Let's briefly talk about the non-public schools, because this one's an even easier conversation than the public schools. In public schools, there is more ability to have influence over them because it's public taxpayer dollars. it's part of the whole public entity. Private schools are private, and by nature, they have less requirements. If they want to be voluntarily recognized, then we're going to talk about that. One of the things that House Bill 2789 was trying to accomplish too, it was trying to compel local school districts to have to follow this new guidance, right? They were trying to force their way into, and if you listen to that 1 hour thing of Senator Bell, there was representatives of the Catholic Church on that call that had huge issues with that, right? They're like, because they were trying to pry their way in to the influence of how those schools operated. Because right now, being recognized as a private, non-public institution is purely voluntary. What's the benefit for the most part? Sports, right? Sports. And so there's been a couple of school districts, private, that got this under 425.60. Get to that. But before I talk about that rule, remember when I told you that the law trumps, the rules have to be in conformity with the law, right? So under the law, the State Board of Education is authorized to delegate certain parts of their authority to the superintendent. They can't delegate all of their power to the superintendent because remember I told you the board is a deliberative body. They have to contain the power over the important decisions. They can only delegate ministerial stuff that's not as significant to the state superintendent because she's one person, otherwise could be subject to more arbitrary and capricious decisions because she's one person. It's a human condition. So the State Board of Education may not delegate authority to the state superintendent to non-recognized school districts. The state superintendent, under no authority whatsoever from the legislature, is allowed to non-recognize any school district, including a private school district. But how many of you know that there's been some private schools that got a letter from Dr. Ayala directly that says you're no longer recognized? And I don't have to go any further than to read 105 ILCS 5/1 A-4. State superintendent may not be delegated the authority from ISB to non-recognize a school. That's it. Okay? But what do they send? What do they send to your school? I've already seen the notice. Under 425.60, I've given you guys a copy of it. Looks like you got it right on top, don't you, ladies?
Yep.
Okay? I'm going to show you how clever people play with words. And I'm pretty good at it, but you know what? I'm at least the kind of guy that I'm not going to hide the ball. I'll just tell you how it is. Read that, 425.60. A non-public school's recognition status may be, what's the next word? Does it say revoked? Changed. What does that mean? It doesn't say revoked because that would be in direct contravention of the statute. It says may be changed by the state superintendent at any time to reflect information confirmed during compliance monitoring. See that? To the extent probation, revocation, etc. To the extent that this, now look at the date. When was that put into place? See the date? September of 2020. It was well into last school year when they were looking for ways to grab a hold of your school districts, right? Private as well. They added this rule. To the extent this rule would be interpreted to suggest that the state superintendent on her own volition could immediately non-recognize a private school is unlawful because it exceeds the authority that the State Board of Education could have ever granted to Dr. Ayala. There is a school district lawyer in Northern Illinois that represents private schools that agrees with what I said, says I'm exactly right, but she won't say it publicly. Why do you think that is? Figure that out for yourself. Let's move on beyond the procedural problem of non-recognizing a private school by herself and look at why. Why? Remember the substance? Why you can non-recognize a non-public school. And guess what? Title 23, Part 425.30, which I've given to you, requirements for recognition of a non-public school district. They're not near as voluminous as the requirements, the standards that a public school has to follow for again, for good reason. You have it, ma'am?
What was that number again?
425.30, requirements for recognition. You have it?
Make sure you think it's-
You're welcome. What does a non-public school have to be in compliance with to have their voluntary recognition stay in good standing? It's 5 pages long, and like we have part 180 of the public code, we've got section E of part 425.30. Section E talks about health and safety. Well, certainly we can go into the health and safety provisions and find something that could remotely be construed to suggest that if you don't follow this state public health guidance, that you could be suspended, right? There's 8 provisions. Number 1, the facilities occupied by the school comply with applicable local building code and fire safety requirements. That's not it. The school provides reimbursable food service. The program has to follow federal law. It's not it. You got a wellness policy. It's requirements of another federal law. Number 4, the School Safety Drill Act is complied with. Number 5, the Eye Protection Act. Number 6, toxic art supplies. Number 7, asbestos abatement. Number 8, 22-80 of the code is complied with. That is the helmet law that you guys are aware of. Folks, there is nothing in those requirements that says that your non-public recognition status can be revoked for not following public health guidance. It's not remotely in there. So not only procedurally is Dr. Ayala not able to immediately suspend you, substantively, there's no reason that she could either. But you know what, guys? None of that matters if you're going to do what Timothy Christian did. Right? Timothy Christian, you guys saw that story? The gentleman, I think his name was Matt, made a very articulate and eloquent comment about we just want to know the answers. Right? We need to be assured. School hadn't started yet. What do? They fire off your suspended, revoked, whatever you're going to call it. And I'm laughing, going, you can't do that. But you know what? They said, okay, we'll comply. If people aren't willing to ask the questions, government can do whatever they want. And it's not unusual if you do what I do. Every day that passes in this world, government agencies do things that they've not properly been delegated all the time. In every aspect, it happens all the time. The only reason it'll stop is if people say, I got to ask the question, where this grounded at? Is it un-American to just merely say, we need to know the answer to this, right? When did it become confrontational to say we're going to defend ourselves and at least get these questions answered? So for non-public schools, it's really quite simple. But yet, there's not yet. I've talked to a couple of, and I have another meeting tomorrow with another one, and I've asked them, you have to decide, do you want to ask the question, right? And again, that question may require you going to a courtroom. Nobody who likes to go into a courtroom besides lawyers. Nobody. Sometimes your back's against the wall, you don't have a choice, right? And keep in mind, both of these conversations we've talked about with 100% certainty have never had a case in the last year and a half that has anything to do with any of this. None of them. Whether or not the governor's been, I'll say it over and over again, whether or not the governor has been said you can write these 30-day proclamations forever until there's no disaster is a completely different question, 100%, than whether Dr. Ayala can do what she did in your school district. One has nothing to do with the other. So the last thing I have, guys, is to do with your kids in quarantine. Isn't that a good word, quarantine? How many of you have children that last year their third cousins, brothers, best sisters, half uncle's dog got the COVID, and little Johnny might have been in the same building with them, and so little Johnny got quarantined for 14 days. Happened to my kids several times. And you know what? I knew the law then, just like I do now. I didn't do anything. I said, I don't care. The question is what has to happen in order for your kid to be told they can't walk in that school? Because your public schools are different than private schools, but for public schools, your child has a constitutional right to walk in that building, sit down, and say, educate me. And if you're going to prohibit them from doing that, you can only do it as allowed by law. So every now and again, these administrative agencies make a mistake, and they'll actually write something that states what the law is. They don't like it when they do that. But in May of 2021, the Illinois State Board of Education passed a resolution. Anybody read the resolution about requiring indoor or in-person learning? Anybody said that? Okay. There's May of 2021, in-person learning is required. That's actually ISB making that proclamation. It is within their discretion. And they put at the end, all schools must fully resume in-person learning for all student attendance days. You guys are familiar that the statute says you have to have so many attendance days, right? And it says, provided that, pursuant to these provisions of the law, remote instruction made available to students who are, one, not eligible for the vaccine, which has been interpreted for kids that aren't vaccinated, and the word "and" in this resolution is bold, under a quarantine order. Quarantine order. That is an actual legal document, and I've given it to you. It's called an order of quarantine of an individual. That document was most recently updated by the Department of Health in January of 2020. An order of quarantine is an order. This order can only be forced against a citizen, including children, under two circumstances. Consent of the parent, if it's a child, or a court order. Because you're talking about restricting a citizen's ability to move about. That's a big deal, right? And you can't do that with what we call in our firm the quarantine call, right? How many of you got the quarantine call for a child? Yeah, whatever that lady, that poor lady from the Department of Health had to call me. I think they drew short straws for going, who's going to call Tom and tell him his kid can't come to school? She's a nice lady. And she'd call me and say, yeah, Tom, Maddie, it's one of my daughters, can't come to school today because little Johnny's third cousin, brother, blah, blah, blah. And I'm like, okay. And she has to stay home for 14 days. I'm like, yeah, Scooter, that's not good. But okay, can't go to school. All right, I'm not going to argue about it. I knew then, as I know now, that it was not proper because you have to have an order of quarantine. ISB actually wrote it in their resolution. And 2 months later, when Dr. Ayala wrote her little spiel to the superintendents, read the language if you guys haven't seen it. It's verbatim the same as the resolution of ISB, except they take order of quarantine out and put guidance from the local health department. Guidance. That's not the law. You can't quarantine or restrict the movement of a child because the health department thinks that it's proper under their guidance. If the health department says that your child's movement has to be restricted, it has to be done by consent or a court order. Now, there's a 48-hour emergency provision in the law that they could say you can't do this for 48 hours. It's lawful. Legislature passed it. But within then, they got to have you in court, okay? Once they take you to court, they have to be able to prove that the person, and we're talking about a child here, actually has COVID, has been around somebody with COVID, or reasonably believed to have been in contact with COVID, in such a way that factually they could present a risk to the community. They have to prove that by clear and convincing evidence, which in the courtroom, way up here. That's what they have to prove if they want to restrict your child from going to in-person learning, and ISB wrote it in the resolution. And the school districts are saying, for the most part I've been hearing, well, we have the guidance that the health department said. It's absolutely not possible, but what it would require is a parent saying, tell me the facts on why you think my child should not be able to go to school, etc. And if the facts are such, your child tested positive, you may consent to that. I mean, that's fine. But if they get the story to you as a parent, well, little Johnny's on the football team, and little Jimmy's little sister caught the COVID, and yeah, we know your son wasn't at practice that day, but they might have been around each other, so he can't come to school. Those facts are loose, right? And I can tell you that's happening right now. And a parent could say, sorry, I don't consent. You need to get a court order. And what they're going to say is, well, we don't need a court order. We got, the guidance, and so you can't come to school. Your only choice is to go to court and try to get an order from a judge that says, ISB tells us that you have to have a court order for quarantine, or they got to let my kid in. Now, what they may choose to do based upon a parent insisting that they follow the law, is they might get an order of quarantine. They might file something that says, we think that little Johnny needs to be quarantined because of these facts. And they may win that argument. But my point to you is that if you take the school district down that path and the Board of Health, they're going to then be more selective or appropriate about who they choose to say can't walk into school versus whatever willy-nilly decision the Department of Health makes. They'll follow the rules, and they're not going to quarantine every child and keep him from going to school because they think it's a good idea. But a parent has to push that issue, otherwise they're just going to ignore it, okay?
Why can't a school board just say, we're not going to do this to our students, we're not going to do this. This is our school board policy, we're going to follow the law that says you have to get a court order.
I think that's absolutely perfect. If a school board would choose, and I'm not advising, but if a school board chooses to say, look, I don't care what Dr. Ayala says in her little letter to you, I have the resolution, and I read it to you, that says we have to offer in-person learning unless no vaccine and a court order or an order of quarantine, let's say the parent consents, right? And unless you got that order of quarantine, Johnny's coming to school. And if health department, if you got a problem with that, go get the order and we'll listen. That to me is what every school district should be doing to be compliant with this, but how many of them actually do that? If you choose to do that at your school, sir, you'd probably be the only one in the state.
And meanwhile, the child's going to school.
Absolutely.
Absolutely. The child's going to school because there's a lawyer involved again. It takes time.
Maybe not a lawyer.
Literally, it'll take 2 weeks probably for them to get that order done.
Now, they could get in the court quickly, but there may not be an order. There may not be a lawyer involved potentially, because if the school board says, we're going to follow the rules, and if you've got an order of quarantine, we will not let the child in because that's a lawful document. But unless you get an order of quarantine, don't be telling us that little Johnny's got to stay home because we're following ISB's resolution. I don't care what Dr. Ayala says. She doesn't override ISB. And if you do that, the school board, or not even the school, the Department of Health may not choose to go pursue it. The parent may not even need to get involved because the school district, to me, is doing what's right and not merely just blindly following what somebody's telling them to do. Yes, sir.
How about a school that's following the mandate and students show up without masks on? Are they legally required to educate them?
You know, that's a good argument. My opinion is yes. I think that they constitutionally have to educate them or provide accommodations. The problem is the practical reality is when kids start showing up, and I've heard all the stories that they tell them to go home, et cetera, that becomes so overwhelming that today, at this point in time, there's no quick remedy to that answer. And so it creates this conundrum. I think there is an obligation to, heck, if you guys go into your discipline policies even, it doesn't mostly say that if over 4 days, the kid's not going to be allowed in school, you have to find a way to educate them or something. So the discipline policies even don't address this. This is such a weird set of circumstances that these fact patterns that you bring up, there's so many of them and there's really no direction. I'm just trying to get school districts, specifically to the recognition status thing, just ask the questions, go down that path before you just give up and say, I'm going to do, because for God's sakes, you guys, our kids are watching, right? Our kids are watching this. And my kids are 18 now, but kids that are younger, and even my children, because there's going to be another emergency, I promise you, and it may not even be a virus. And are we going to say that when we have an emergency that we're going to resort to this top-down executive fiat mandates and administrative agencies can do what they want? If that's how we're going to govern ourselves, guys, it's going to be a real problem that's far beyond the mask issue. To me, this is even not about masks. This is about, are we going to respect the rules and the laws, and if we don't like them, change them. But you know what? They didn't get the law changed to try to do what they're doing, so they're trying to utilize fear and intimidation, and it's been pretty successful, right? It's been successful. So what, and I'll answer all the questions you want. So what we've been doing is I'm trying to find a way, how can we put it, not even put it in, how can we take the position that we've got to make sure the rules are followed and the laws are followed, and if the rules and laws right now are such that they can do this, that's only going to be answered either one, maybe JCAR will handle this for us, right? But if not, does it take the court to solve the problem? Could, right? Courts are never the best solution. But if it comes to that, it's the only point we have, then we have to do it. So what we've done is I'm actually leaving now and we're going to Chicago where I've met some people, and I've got a not-for-profit that we've set up some time ago to deal with these types of things. Education, which this is all about just talking about the rules, and potentially funding these types of cases to help get the answers. And I've got people that are going to do that. Okay, and so I'm in a position now to where we're going to go hire, or I'm going to go find from other firms, lawyers that know how to fight, right? They know how to come in and say, these questions that Tom has laid out, we're going to go ask them for people if we got to, because JCAR doesn't handle it. And all we're going to be looking for is school districts across this state. I don't care if they're mask required because they are going along, or if they're mask recommended. We need a bunch of school districts that are willing to step up and be party plaintiffs to say, we're going to go ask the questions. We need clarity to this. Is our authority been stripped from us? Yes or no? If so, where in the law is it? And let the courts at the highest level answer this question, because this needs to be answered not for just this issue, but for the next issue that comes and the next. And so that's what we're trying to do, is to, one, give this information, and one, put something in place to where we can try to help get a bunch of districts together that merely want to go ask the question. Yes, sir.
When do you anticipate that happening?
In the next week or so.
So I got a question.
Yes, sir.
Boots on the ground right now, Monday. You got schools having meetings with ISB. You got parents, everybody freaking out.
Mhm.
A couple school board members even at different times. They're gonna, they're just gonna, we're gonna lose our whole school if we go non-recognition. Right now you're under probation.
Uh-huh.
You got a meeting with ISB. ISB is not gonna do shit. They're gonna.
You know what they're going to do,
Yeah,
sir.
I know what they're gonna do. So then how do you go to your school board? What's their option, or what's their choice? Just hope, stay strong, let's say, and hope that we can get through another week, another 2 weeks. Because ISB is probably not gonna answer these questions that are thrown at them.
You think they'll answer the ones that JCAR's throwing at them, or you think they'll snowball?
I think they will. I don't know how they'll answer it, but my point is, you've got a lot of schools that have already flipped back, I'll say. You got some that are worried about it, but we need to not flip back. How do we not flip back? I mean, is there a good solid way other than just grit and guts?
Without giving legal advice, because I don't represent any of your school districts, the conversation has been had because right now you're within that window of 60 days, right? Yeah.
It hasn't started yet.
It starts after you have the initial meeting,
You're going
right?
to make an amendment to that, though. In the rules, though, it does say if something that should be easy to accomplish, something like wearing a mask, and if that is the difference of you being on probation versus recommended, they're saying, is that time frame, if you allow that to go on for 60 days, is that time frame acceptable in their minds to be able to handle such tasks as that? They're going to say, that should have taken 1 day. That should have taken 2 days. And then they can come back, and that's going to be the next hurdle to jump through, because now you have to do it within their time frame that they deem as acceptable to make such corrections.
So it says 60 days, right?
It does, but it also says.
I think I can clarify what you're saying. My opinion is, just my general opinion, is that if school districts who are recommended are not going to make the decision to go ask that question, even if that means asking it in a courtroom, they get into that administrative gamesmanship that you're talking about. You're not going to come out on the good end of that, because you're asking the very agency that you think is overstepping their authority to not do something. And it's just counterintuitive, right? And so, to me, these questions, there's really 2 of them. Procedurally, can Dr. Ayala do it? Substantively, is there anything in the code, particularly health, life, safety? Those questions have to be asked.
We have to redirect.
Huh?
We have to redirect.
What do you mean by that, sir?
Meaning, don't go down that road. We just have to redirect to get it back to the procedural and subsequent stuff.
Yes, and again, if once you start going down that administrative road, is there a question to be raised that you kind of acquiesce to their ability to be able to do those things, right? And so, to me, again, even school districts that have went back, whatever they are, if 10, 20, 30 school districts all join into an effort that says, we're going to go file something and we're going to ask these questions, right? We're going to ask them. And at the same time, you would be asking the court to say, while we're asking these questions, you need to put a halt to all this recognition status stuff, right? It's called an injunction. You're familiar with that language? To me, again, I want to be one that plays a role in this, but I've already made it clear to the people that I'm working with. I've been doing this a long time. I want nothing better than be an ability to go get 6, 8, or 10 guys, and I know who they are. They're litigators, man. They're not policy bureaucrats. You know, they're guys that know these rules. They're going to go do it. And go in and say, we're raising this question. We're going to raise procedurally and substantively, do you have this power? Yes or no? And oh, by the way, Judge, while you're answering these questions, the information is such that you ought to put a stop to all this administrative stuff until we solve this problem.
So what about say advocacy groups, parent groups, and things of that nature? Do they have a role in this, possibly raising money for school districts or going to court themselves on behalf of the schools?
They do have a possibility to do that. Certainly there could be a claim by a parent, and I've actually got one of those pending. I think that the clear dispute is between the school districts and ISB, right? You know what I'm saying? So I think they're proper.
That would hold more power.
I think it raises the real issue, because otherwise the parents are raising it derivatively for you. But as to the financial part, I'm working on that right now with this not-for-profit. I'm trying to raise the funds to where it, because there's a lot of people up north that are willing to help, because they don't think that the taxpayers of Southern Illinois, even though we're not Southern here, should finance all that. They're willing to participate. So if I can put together that part and say, we've got the resources raised to help do this, the school districts just have to be prepared to do it, right?
I think there's a lot of money that can be raised in our areas too, is what I'm saying.
That's coming. That'll be public here really quick, but we can talk about that when this is over. But I mean, that's really the question. And again, leave all of that aside, because none of this to me has ever been about the financial part. If it was, I wouldn't have done anything 18 months ago. I'd have kept just practicing law. This is about, we have to bring clarity to this. If a court wants to step up and say, we've interpreted this stuff, and this is how we see it, that's what it is. I think the interpretation is pretty straightforward. I would never say I know how things are going to end, but if a court wants to say, we have clarified this, and based upon our legal opinion, ISB's ability to suspend recognition status is ironclad in here, then you guys have to react. Right now, you don't know, and what you don't know across this state is causing havoc, right? That question has to be answered, in my opinion, because it's something that the people need.
Are they able to get a local judgment from or county judge?
That's a good question. The cases that have always been transferred, I don't want to get into that because we've talked about this, been transferred to Sangamon. And again, if this issue has, let's say I'll make up a number, 50 school districts, if it's in Sangamon County, so be it, right? Eventually, the ultimate answer to this question is not going to lie in Sangamon County or Knox County. It's going to lie in an appellate court or maybe even the Supreme Court. I think this issue here that we're talking about is important enough that the Illinois Supreme Court needs to answer this question.
For the time being, though, is there something the county can do?
Potentially, but again, that's getting into more to an advisory thing about that specific issue, which is, we could talk about private, but beyond just a general conversation. Yes, ma'am.
Okay, is there a procedure to withhold our taxes and dispute them if we, the community, doesn't agree with what the school districts are doing?
No.
Okay. And another question. A friend of mine claims she watched a video where the school board went against the parents' wishes and the community members voted the board members out on the spot. Is that a fantasy? Is that possible?
That was a fairy tale. There's only ability to people want to recall their board members. It's fallacy. There is some authority under I think the regional superintendent to remove for gross malfeasance or completely inappropriate. These are policy decisions. And just because an elected official makes a policy decision that they don't agree with, unelect them the next time. But there's no way to go in and grab a hold of that seat like that. There's no authority for that, to my knowledge. Yes, sir.
So how does your case that you have regarding the parent, how does that differ from what we're dealing with here? In the determination that you're going to get in that case, won't it apply to our schools?
Potentially. That's an excellent question. There was two questions that could be asked. What I'm talking to you guys about doesn't even ask it. Because, make sure I do this so you guys understand. When you're dealing with the executive power of the governor under the Emergency Management Agency Act, okay? It's 20 ILCS 3305. That's this emergency act that if we have an emergency or a disaster, it gives the governor power for 30 days to do 14 things that are listed in the emergency provisions. What's been happening is, and again, I won't go through, I could talk about this for an hour by itself, but certain things comprise a disaster. And once the governor proclaims a disaster, assuming we have one, he gets he gets regular powers under Section 6, as long as the disaster's going. He gets these emergency powers for 30 days. So what he's done is when he issues a proclamation of disaster, he puts a 30-day termination date in that proclamation that the law doesn't require, but then it expires, the disaster, the 30 days. Well, he issues a new proclamation for the same exact disaster, and it starts that 30-day clock on his powers all over again. We argued those cases all along, okay? And the court still now said you can create that ruse. I disagree. Beyond that is the question of within those enumerated provisions, what is the breadth of the ability of him to issue orders about what? Okay? Under those 14 provisions, what can he do? What can he not do? As a parent, we have raised the argument in Clinton County is, does the governor himself have the ability to issue an executive order that strips local control away and gives that power to the state agencies? Does he have it within that law? And we're saying he does not. Set that question aside, and let's say hypothetically he does have the ability to issue that executive order. How you might enforce that executive order is a completely separate conversation. Does that make sense? And the question is can you enforce it by threatening recognition status? Because that then becomes the relationship between you as a board member and ISB. And that relationship and any authority between those two parties is separate and distinct of what the governor's ability to do something is. So even if the case that I have pending, if they said, oh, the governor can issue this executive order, that doesn't mean your school districts are lost. That just means that they have to figure out how to enforce that executive order. Does that make sense, sir? Okay. And you probably would not hear a school board lawyer give you the answer I just gave you. I'm just saying this. I don't know why. But yes, sir.
I think most schools, districts in the state get behind a group of lawyers that can push forward a lawsuit.
I'm going to have 10 of them. Best litigators I can find.
You're going to have way more school districts. I guess what I'm interested in is we're doing that right now at our school, even though we are still past optional, we haven't gotten a letter from the state yet.
Don't say when this is rolling, they're probably going to send you one. But go ahead, sir. They can't see you.
Several, I know at least two that I know of other districts, their resolution to go back to mass required also included wording to seek legal representation, pursue it.
Uh-huh.
So they want to do it.
Okay.
They just want to do it without the threat of.
You already paid for legal up.
Well, the problem,
they don't want to do anything. They don't want to
because the problem is, our lawyers are not the ones who want to fight.
Can we replace them lawyers? They're appointed by the state.
They're not appointed by the state, sir. They're appointed by the school board. School board.
But can we retain our legal counsel currently for policy?
Absolutely.
And then seek additional counsel for this?
I think that's a wise choice. Would you, and again, there's a school district down south, we've had this conversation of you have school lawyers, they do policy, they help with manuals, they help with guidelines, they help with bond issuances. That's a valuable asset. Do they litigate these types of issues, yes or no? And if you as a school board believe that that's not, you can hire special legal counsel of any person that you wanted to.
So I think what we need to do, because we need to get a team of 10 lawyers, right? Or 20, I don't care, whatever. And whatever that amount of money is, at the end of the day, if we can get 700 school districts in this state to get behind that litigation, that makes it a lot cheaper for all of us.
Not only does it make it, again, I'm working on not-for-profit help. I'm looking for not-for-profit help to help with that too on behalf of, because the taxpayers will be funding this, right? Now, sadly, I'm going to go ahead and say it. It should be the Attorney General's office bringing this on behalf of the people, right? That's my opinion. Take it for what it's worth. But we don't. So now you're right. If overwhelmingly the majority of our school districts said, we went back to mask required, that's fine. But we got a question. And what questions do we have? The ones that we've talked about today, right?
I know everyone down by me would do it in a heartbeat. They're looking for that answer, but they don't know, they can't get their own lawyers to answer these questions for them, so they don't think there's any way to go.
You're on the school board, sir?
I am.
Have you ever heard any of this conversation that we just had before today?
Absolutely not.
Okay.
I'll be honest with you. I've got a couple board members that say, oh, we can't listen to that Tom before. He's running for office and all this stuff, and I made a comment.
I've been doing this for 18 months.
My comment to them was, he's the only one giving us anything other than negative.
I answered that question to a reporter, and I said, you know what? I said, I decided for personal reasons about a month, 6 weeks ago to run for the appellate court. I've been fighting this fight since March of 2020. If I would have said I'm running for the court, and then I started doing this, I would be all of you going, hey, you know, that's kind of suspect, right? I've been fighting this fight a long time. It's got nothing to do with it. And actually, believe it or not, I'm not here even, because I'm not even in this district. I'm in Southern Illinois. One of my main reasons for doing that is if I do make it to the bench, I've got a whole lot more free time to do, you know what I'm doing right now. Because I believe firmly that if people aren't informed and educated on how these things all work, that we're going to have problems as things continue. Because our children and our adults don't really appreciate the structure of how government works, and that's important. But they're not. But the things that I've just explained to you today, you've never heard me one time say what I think you should do or should not do. You've never heard that. What I just explained to you in these rules is not rocket science. I mean, it's once I break it down, you men and women can think for yourselves. Well, yeah, I understand that argument, right? We need to have that question answered. And anybody that would suggest to you that you should do this or should do that, I have never in my life as a lawyer ever told a client what they should do or not do. That's not my role. Yes, sir.
Keep that conversation going. I think it's, you know, school board member, I know I talked to a lot of school board members from other districts and stuff. And the biggest concern is that we're not getting legal advice to this side from our lawyers. We don't know what to do.
I understand.
All we know is that we're going to lose our school and our teachers are going to lose their pensions, our administrators are going to lose their licensing. But if we knew there was a team of lawyers that were as interested in fighting for these kids as what we are, they would jump on them.
I've got them.
They just need to know how to reach out to them. We need to establish communication with districts so they know that hey, the more schools that jump into this fight, the cheaper it is for all of them.
Right. And keep in mind, and again, I want to make it crystal clear that none of this for me, and you guys don't know me, has never been about financial, right? It's not to me. This team that I'm trying to put together, you know, I may be on the documents as one of the lawyers. I don't even plan on doing a lot of the work because I have this knowledge. I want to give it to a bunch. I mean, I'm getting tired, right? I've been doing this across the state in various capacities. I would love nothing more than to take a big group of school districts, put this team together through, again, this not-for-profit activity and say, go get them, and I'm going to stand here and watch. I don't need the limelight. I mean, I live on a farm. I'd rather be at home fishing and playing with my cows than I would out here. I just want to bring it all together.
Yeah, somebody's got to facilitate getting.
I want to bring it together, sir. That's all. Yes, sir.
So will you be getting us the documents we need to vote on at our meetings to join your?
Well, I think that's something that you would policy-wise, again, I don't represent your schools, but if you as school districts, again, make that decision that you're going to take action to pursue the answers to these questions, and you're going to then engage, you know, special legal counsel, whoever that might be, you can do that through your board activities. Again, that documentation, you know, your school lawyers, if you're choosing not to use them for this effort, you can tell them this is what we want. I don't know if your super usually drafts some of this stuff, these resolutions, or if it's different depending on where you're at. But that's what you'd want to do, sir.
Well, maybe I misunderstood you. I thought you were wanting to get schools to be on your lawsuit that you're going to.
What I'm saying is that we're going to put together a program that gives schools that opportunity if they want to. But as far as how the mechanism of which they go authorize themselves or their superintendent to participate in that, I mean, that's within their local operations. If they reach out and say, X school district, Tom, we have voted, we have acted to the extent that this is going to be done, we want to play a part in that. Once I have that information, I'm trying to put people together to get this to happen. That's what I'm trying to do. And to me, guys and ladies, it's not really confrontational, right? Because your decision of what you've decided to do locally, it's none of my business. These questions of the extent of which your authority can be taken away under the threat of recognition status, we have to answer that question. And that way you all know what the answer to that question is, and you can conduct yourselves appropriately without your communities coming apart at the seams. Because I had a kid, a 7-year-old boy, email me night before last. I was on the way home from bringing my third kid home, go to college, because I have triplets. And I was already in a depressed mood. I got a 7th grade boy from I don't even know where send me a nice message about how he appreciated what we're trying to accomplish, how he missed a whole year of school because he couldn't keep up with remote learning, and that, wearing a mask, he has anxiety. And you know what he said? What can I do to help you? Right? And I thought to myself, I have a 7-year-old scared child asking me what to do, and I told myself, I have to do what I can to put this together so these things can be resolved, because, again, it's tearing these cities apart, these counties apart, and it's pitting you men and women against the community, and it's heartbreaking, and we have to answer the question.
Well, I think if school districts realize they can get additional counsel for this,
Mm-hmm.
you're not firing your existing lawyer.
Right.
He's just not the best bet for this.
You would have a counsel specifically for asking these questions. It's called a declaratory judgment action.
What we need clarity that by pointing against the governor and making it mask optional, mask recommended, that there's going to be no, consequences from Disney or whoever else. We need somebody to confirm that with the judge so they can't threaten us.
What we need somebody, and he might be putting together, but I've said this all along, we need a fighter. We don't need to send a tennis player into the.
I know how to
That's why we don't have any school attorney came today. There's nobody to ask him. I'm not on the school board or anything, but nobody on the school board.
That's going to be part of the plan. Yeah, and it is, and that's what I have listened, and again, I always try to stay quiet because I try to stay out of the politics. I have listened to school board lawyers across this state. I think up here in this area, one of his names, Mr. Penn, and actually on public being recorded wants to criticize me, right? Wants to criticize me about these things, and I sit there and go, you know what? All I'm doing is telling both sides of the conversation, right? There's two sides to every coin. This to me seems pretty clear. A reasonable mind might differ. I'd like to hear their arguments. I would love nothing more than Mr. Penn to stand right here with what we just talked about and not try to scare you with conjecture, but answer these questions. Does Dr. Ayala, under Part 1.20b, have the authority outside annual compliance to suspend or put you on probation? Yes or no? Don't talk about redirecting. Answer that question, right?
Those questions you sent me, I put our attorney through the ringer in front of 150 people, and he just kept running circles the whole time.
You can tell, right?
Direct answer.
Mm-hmm. And I want you to know that if I'm being asked questions that I don't like, I'm going to run in circles too, right? I'm always in a courtroom where I'm going, and we as lawyers usually know what the issues are. We know which ones we don't like, and our colleagues will know. And so when they try to pin us down, we start running around the other circle. It happens, but it's sad when we're doing things like that. We don't do that at the expense of children, ever. If I'm in a courtroom with two adults that have a fight, we'll do those things. But when you're dealing with babies and these types of things, you don't play games with words. You call it right down the middle. If you have a legitimate disagreement or a dispute about something, you solve it, right? You solve that issue, and you don't try to pretend that one side or the other should control the situation, right? Because even if you have, again, counsel that believes you should be doing something, I personally believe you have an obligation to lay this other side out, right? Lay the other side out and say, school board, you got to figure out what's the best decision to make, right? You have to decide.
For unbiased opinion.
Yes, I understand. Yes, sir.
Can we go back to the quarantine discussion just for a moment?
Yes, sir.
So, to me,
being on the school board and seeing what I've seen the last year and a half, in my opinion, quarantines have done more damage to our kids than probably any other thing that we have done.
Policy-wise, I agree with you. Go ahead.
So, and this is the first I've heard about any possibility of any recourse regarding the quarantine. So what's gonna happen? And I went through it with my own child a couple times last year.
Yes, sir.
So what's gonna happen, we get a call from the, first of all, we get a call from the school nurse says, okay, I'm sending your child home because they've been identified
Close
as
contact.
close contact.
Yes, sir.
Then the next day, we get the call from the health department that says your child's quarantined for 14 days.
Yes, sir.
Now, first of all, I guess, what is the ISVE quarantine resolution that you spoke of? I'd like to look that up.
Okay, if you type in the internet, and I have a copy of it that I think, I didn't bring a whole copy, but if you look in May of 2021, the Illinois State Board of Education promulgated a resolution. It's for getting in-person learning back in action, okay? And I'll give you my email, you'll find it, I mean, you go to the internet and search for it. And that was because let me give you the backdrop to that. The legislature has mandatory in-person attendance requirements in the statute. You're all familiar with that. Last year in June, what many of you may not be aware is that the legislature snuck in a provision that amended the school code that says under an emergency situation, the State Board of Education could suspend those attendance day requirements and allow for remote learning if they have to. But that was a specific statutory provision that gave the State Board of Education that authority. And so last year they did that. They had in-person, they had hybrid, etc. They realized how damaging that was to the like the little boy that called me, lost a whole year of school or messaging. They know that in-person learning is absolutely superior. So to that extent, ISB issued that resolution in May of 2021, making it clear to all school districts, and it is binding on them, that you cannot do remote learning, you have to do in person. And if you're going to have somebody go remote, it can only happen under these lawful circumstances of no vaccine and a quarantine order. That resolution, I would suggest to you, is binding upon your school district. And I'm just asking that they follow the resolution that is be promulgated. So yeah, you'll find it, sir. And not only will you find it, I'm sorry, I'll come right to you, where it says and in order of quarantine, and is bold. So they really meant it. Yes, ma'am.
Okay, so I'm gonna ask you to look into your magic crystal ball, do a hypothetical analysis of all the directions you could foresee this going. Let's say 50% of the kids in the high school level, let's say, show up to school, refuse to wear a mask, refuse to go in the building without a mask. How does that play out that day, long term? How does that go?
Instead of William Wilhauer, who's a representative down south, doesn't call that civil disobedience. He calls it righteous indignation.
I agree.
I like that. You know, I don't know. I try not to get into those conversations, but I can tell you that when the people have had enough, everything comes to an end.
I feel like that's the only solution.
You could be right. And because I had a constitutional law professor that told me once, a long time ago, he says, Tom, if you ever see in your lifetime to where things like we're talking about right now, but on a more serious nature, even I would suggest to you, he says, no branch of government will save the people. He says, the only way is the people to save themselves.
Exactly.
And I agree with him, and he's right. And again, are we at that point yet in our development of a society? I sure hope not, right? I really hope not. But I do know if the people have had enough, even legislatively, and I would suggest to you now versus a year ago, they're getting there. 16,400 witness slips in opposition to House Bill. You don't ever hear of that. So legislatively, I still believe that the people have enough power to influence this before they have to consider going to what you're talking about. But again, to the extent that they would make that decision, I understand. I mean, what if you had a school district, hypothetically, that every kid in the high school, just parents take them home? You don't have anybody. Yeah, I don't know. Does that even make sense? Or they all walk in there, all however many kids in the school, they don't have a mask on. What are you going to do? I mean, that type of pushback, it's powerful. Do we need to do that yet? Well, I don't know. Like I said, I'm just one person. You all can figure that out better than me.
So I don't understand the 16,000 that we listened to. I mean, what good did it do? What good did our voice do in there?
Well, it's still, even though you had 16,000 opposition slips, it did come out of the Senate committee, the executive committee, and went to the Senate floor. Where if the Senate would have passed it, it would have went to the governor for signature. It died on the Senate floor with a super Democratic majority. So those 16,500 people, it made a difference because you had enough, again, Democratic senators that said, I'm not going to political suicide and pass this because the people are pissed. So it did make a difference. Yes, sir.
So JCAR questioning is
Big deal.
Friday, yesterday. So what are you hearing? What are you hearing that's going to come out of it? What are you hearing anything?
What I've heard so far from a couple, indirectly from the committee members, that they are questioning where ISB, because what you and I are talking about right now, that 8-page letter, I guarantee you every committee member in JCAR has that, right? It's no secret that I've put that out there.
So does ISB.
Huh?
So does
ISB. Did you hear Senator Bailey and House Member Blaine Wilhauer talking on the floor? Did you hear the things they were talking about? They sound familiar, right? So these things that are being talked about, these committee meeting minutes where they've said these things you folks are listening to, that's creating a lot of pressure, right? And so for this committee to come out and say, hey, you got to talk to us, because what they want, what I believe JCAR wants to do is they want to get out in front of a real issue to show to me that they're showing, hey, we're stepping up here, right? And that's, so what will come of it, sir? Boy, I don't know. But the mere fact that they're digging into that to me is important.
So if this goes south, as far as in our favor,
yes,
I'm not saying it will, but
I understand. I know where you're going.
What kind of credibility is the governor, the ISBE, the IDPH, all of those things when it comes to related to schools? How is ISBE going to be viewed in the future if they're basically cheating on us right now?
You know what? What if we, when I get the responses to my FOIA request, have emails in there back when they were sending them back and forth about this bill? And what if there's emails in there that say, we got to get this bill passed, otherwise ISBE can't enforce anything? What if that's in there? Think about that. That's a big deal. If an administrative body is out here trying to do these things under the guise of authority, but there's actually, they can't just, at that point, they wouldn't be able to play dumb or say, yeah, the court interpreted it differently than we did. What if there's acknowledgement in there that they knew that there was nothing in there? Now, I believe, with my interpretation and listening to these committee meeting minutes, that they didn't believe that there was ambiguous language that they wanted to clear up. I absolutely personally think that's nonsense. But somebody can still say that. But if you have emails that say something to the contrary, that will be a big deal at all levels, because there would be an acknowledgement we don't have the authority, but they're still trying to do it to you. And again, those emails are public record, and if they're in there, I assure you, you're going to see them.
Is there a timeline with getting those?
Yeah, it's probably going to be beginning of the week. I'm assuming they're going to ask me for more time, because I asked for everything I asked for. I want to see it, and you guys need to see that, right? Everybody needs to see that, what was going on, because to me, there was no basis to, now there's lawyers, your school board lawyer probably said, well, but you know, I know what Tom's saying, but just because that bill didn't pass into law, the law already was what it was. It's not like it changes it. Did you hear that?
Exactly. He told us that 789 gave the governor ISB expedited authority to do so.
Okay. Yeah.
I have a question. How do you?
All right.
How do you ensure that you get those emails? I know it's for you. I know it's law.
10 days, isn't it?
No, but I mean, I'm just saying.
That they don't scrub it?
I heard emails disappearing.
I can't answer that question. I like to believe that people are honest, but I understand your concern.
So let me ask you, if you do not get them, will you file with the Attorney General?
You're darn right I will, in a heartbeat, right? And again,
have others do the FOIA requests also, to mass request all the same thing.
you know what? I mean, it's a free country, and so people want to send their own FOIA requests. I'm all about it, right? I can tell you I asked for them because I want them. And I want to see, because remember, what if you heard House Representative Mussman. She said that, you know, people from the governor's office had reached out wanting these changes. Guess what emails I asked for? Every email that Senator Mussman has in her inbox ever regarding House Bill 2789, and I want to see who was reaching out and what they were saying, right? And again, that's what I want to read. I want to see them. But to your point, sir, I don't know what they're going to give me. But if I don't get them, I assure you, I'm going to the courtroom.
Don't give them an extension.
They can get one. I can't stop them, obviously. But
So I was at the ISD meeting.
You were there personally, sir?
I was there personally.
Yes, sir.
I spoke there, but there was, I don't see how you come out of that meeting as a sitting board member and not start questioning a little bit.
Mm-hmm.
I don't know, you know.
I agree with you.
I'm with you. I believe in humanity. I think they're human beings sitting there. They've probably been told a lot of things. They saw regular, normal people tell them something completely different. So hopefully that helps.
It looked like blank stares to me when I was looking at the video, man. They weren't listening.
You guys know who Jason Plummer is?
Nobody.
You guys know who Jason? He's a senator down Metro East. His family and him own RP Lumber, the big lumber company. He's a senator. Jason's an intelligent guy, and him and I were talking. And he says, "You know what, Tom?" He says, "You know what government fears the most? That people wake up and participate."
Absolutely.
That is what they fear the most, because government by nature thinks it has the answers, right? And what they don't realize is they don't. I tell people all the time. I said, if you're measuring it based upon performance at school, I'm supposed to be an intelligent person. Graduated first in my class, student of the year. Law school was like, I was sleeping. I worked 60 hours a week. And you know what? One-on-one, I can probably keep up. But collectively, compared to this room, I'm an idiot. I can't measure my ability to draft conclusions or make answers in a superior fashion as this group of people. Take that and compound it across this county or a state. The collective knowledge of people is the most powerful weapon on the planet, but they have to wield it. And when you get people in positions of government that think they know better than those people, that's dangerous, right? And that's what we've lost in government. That's why, sir, they're sitting there with those stares, because up until now, they've been able to pretty much do what they think's best because we're all asleep, right?
I'll tell you one even worse.
Yes, sir.
They know that in kindergarten, first grade, if you don't work collectively now, your teacher has small groups and things of that nature, they know they don't learn as well. That's what's happened for a year and a half. That's what's going to happen again.
Absolutely.
People don't realize that will lead to not this eventually.
I agree with you 100%. The biggest disaster that we've had in the last year and a half is that at some level, the generations under most of us have sat there and watched us, for the most part, silently acquiesce to the appearance of authority.
Life was good.
Life was good.
Life was good. So you let it go on. Now it's not so good.
But you know what? It's a human condition too, because prior to this country being established, for millenniums, how were we governed? By fear. Rule of the sword, hypothetically speaking, or not literally then, right? Fear controls people. It always has. It's a fight or flight type of thing. And now for the last year and a half, that fear, that same fear mechanism that's in our DNA has been wielded against us in a different fashion. Not with a sword, recognition status, food license, Illinois Department of Professional the Department of Professional Regulation, the doctor on the school board. Did you see that got crushed in a heartbeat, where they were going to go after his medical license because he sat on the school board and disagreed with the governor. But they backpedaled and they hurried. But you know what, guys? All of that type of fear is what they've been relying upon, because fear is effective. It's really effective. And we have an obligation to say, you know what, we're going to set fear aside and we're going to rely upon the rule of law, whatever it may be, to answer these questions and not fear. And we have to sort these things out. You know, the courts, we go to the courts with these issues, and the court's going to render a decision. That decision will give clarity. If that decision is something that the people aren't satisfied with, they have a resolution. You know what they do, sir? They go ask the legislature to clear up and clarify that ambiguous interpretation of the court. right? That's how it works. I've never in my life, and I'm going to keep giving you, I've never in my life heard of the legislature going and clarifying an existing law unless a court has first found it to be ambiguous. It just doesn't even make any sense. So, but that's really what we're dealing with, you guys. And again, we've got to answer these questions because, you know, our children are watching, for God's sakes. Yes, sir.
Just in regard to the quarantine discussion you had earlier.
Yes, sir.
So if the school starts and the administration feels compelled to follow
Dr. Ayala.
Well, really compelled by they would reference the local health department.
Correct.
And compelled to work on their behalf, literally.
Okay.
I think somebody asked this question earlier. Can you just clarify? The only thing you can do is to go for the court order, or what? Go find a court order that says you don't have to be quarantined, or require a court order yet that the kids know you're quarantined.
Well, and absent an order that quarantines you, then you're not quarantined. There would no such thing as an order of not quarantine.
Right, but if your administrators, if your principals, superintendents are following the suggested
guidance from the local health department.
Okay. There's a problem there in terms of actually what happens. I mean, health department calls, kids quarantined, administrator puts kid out of school.
Right.
Parent says, kids out of school. That's the biggest problem they can imagine right now.
Correct.
Kids out of school.
Right.
I have parents that say to me, I just want the kid in school.
Right.
Doesn't matter. I mean, all of this matters, but out of school matters the most.
Agreed.
So what could a school board do to ameliorate that situation?
If the school board itself is of the opinion that it requires an order of quarantine, then that school board could, again, not advising, but what I would suggest, could adopt a policy that's binding upon their administration that says every kid in our school district, unless there's an order of quarantine, will be in this school, and you will not send them home merely because guidance has suggested that is enough. That's what a school board could do if they thought that that was the best policy.
Because if you do the mask optional, and this gets into the weeds a little bit, but if you're mask optional, you have to jump through it. The likelihood of quarantine is increased by about 50%.
Is it?
Well, if you're going to follow all the.
Oh, okay. So we're going to hypothetically under the presumption that all of that means something. I'm doing this on purpose. So.
I understand.
Go ahead. I'm with you.
Well, what I mean is, again, all I want to do is make sure that there are kids in school. The least likely scenario where they're not in school. So if you're going to be mask optional, then you have to basically drop the insistence that you're compelled to work on behalf of the Department of Health to contact trace. You have to eliminate that as well, right?
No, I think they're interdependent issues. Whether or not a child should not be allowed in your school is predicated on no vaccine and an order of quarantine. If there's no order of quarantine, that guidance that you're talking about it's irrelevant, right? If there's an order of quarantine, that order of quarantine by agreement or by court order will control the circumstances of when that child comes back to school. It may be circumstances that somehow mirror this guidance that you're talking about. Well, if the kid had a mask on and had been vaccinated, they got gone for this amount, all of that could be factors that could be considered, but none of it in and of itself is authoritative.
I don't think we're legally required to contact Tracy. That is not one of our.
The school district?
School district.
Never heard of such a thing.
The state of Iowa, you're prohibited from working on behalf.
The order of quarantine, how much of it's hearsay? That's my thing. And my kids are grown out of school, thank God.
I just had, go ahead, sir. I know what you're saying.
But, unless the parent gives them written permission to get their COVID test, how the hell are they going to?
Well, here's how that would happen. I'll give you an example of a friend of mine whose daughter just got sent home on a quarantine call. And the fact pattern is that the little girl that tested positive was on the volleyball team. And according to somebody, they don't know who that little girl is, they won't tell you. And according to the school, her daughter was also on the volleyball team, was in close contact. That's all they say.
How do they know that it's within 6 feet of yourself?
For more than 15 minutes. And I understand.
I will say this, I know of a principal that did bring a tape measure into the classroom, special ed kid.
They did a lot last year.
And measured and got within 6 inches and decided it was 5 inches and decided they were gonna quarantine 3 kids.
My son was 5 foot 8 inches.
After the second time my daughter was, parents didn't fight it.
Right.
Parents didn't.
That's the problem.
They got a call from the school, that was all, that was it.
So that fact pattern, again, these facts, every case would be its own independent facts, right? And so, again, with this fact pattern of my friend, her daughter doesn't know who tested positive. She doesn't even know if she was around her during practice for any amount of time. But the question that mom had is one of two things: go along or let Tom sue him. Because if I sued them, and I offered to do it, and I've told anybody in the Hillsborough, Illinois school district, any parent, if they try to do this to your kid, I can't do it across the state, but this is my school district, I'll do it for free. Because here's the thing, if you're gonna take them to court saying you don't have an order of quarantine, you're gonna put them in a position to have to prove that an order of quarantine should be necessary, which means, you know what, the judge is gonna hear who was the little girl that got positive. Where were they around each other to see if it, in fact, it was a real close contact. But all of those facts, none of it matters if the parent doesn't step up and say, I'm gonna fight. Anybody else?
So what is Hillsborough doing now with quarantine? How are they?
The same thing all the rest of you guys are talking about is got the quarantine call, right? The quarantine. They're doing what they shouldn't do, but until at the end of the day, until the court steps in, they get away with it, and people get frustrated and say, oh, they can do whatever they want, Tom, regardless of what the law says. I said, absolutely, unless somebody's gonna stand up and argue about it.
So without giving us advice.
Yes.
Would you care to share with us how you handled it when your child was quarantined?
I just let it go because at that point in time, I was fighting, trying to keep business owners from going bankrupt and losing everything that they had ever. I had people that would call me, people in their, again, mid-60s, etc., that their businesses were closed and they had lost every dime of life savings they had trying to keep their business and they were, and I was so entrenched in those arguments that I let that issue go.
Some superintendents are actually saying, we don't have the manpower right now to do your contact tracing. This term, this is IDPH.
Right.
Local county health department.
Understood.
And so that to me is a great directive from a board. Say, listen, we don't have to do this. I mean, they're on their own. If little Johnny gets sick and if he's gonna tell somebody else who he was around, that's on them.
True, but it could put you in the same position. Let's say little Johnny tested positive and little Johnny tells him that little Jimmy, who he also goes to school with, was at his house playing ball. And so little Jimmy gets a call, parents get a call saying he's out. School district didn't contract trace anything. Is the school district going to say, okay, he's out without an order of quarantine or consent of the parent? It brings you right back around to that same analysis. Yes, sir.
So, do you know what our school attorney advised us in regards to that? He advised us that anyone who obstructs the Department of Public Health is in violation of a Class A misdemeanor. And that would include the superintendent, any administrators, the school nurse, anybody on the school board.
Wrong. Let me explain it to you.
Did you ask him
Let me-
why they were obstructing that?
He doesn't know what
We're
he's
not cooperating with the health department.
He doesn't know what he's talking about. Let me tell you, Section 8.1 of the Illinois Department of Public Health Act under 20 ILCS 2305 says that you could be guilty of a Class A misdemeanor under the Department of Health Act if you violate, what am I going to say, anybody? An order of quarantine. If there is an order of quarantine and you violate it, either if you consented to it or if the court enters it and you violate it, you by law are subject to a potential Class A misdemeanor. There is nothing in the law that says you could be subject to a Class A misdemeanor for violating the COVID call. So if your lawyer said it's a Class A misdemeanor, I don't say it often, he's 100% wrong because the misdemeanor provision only applies if there's a bona fide order of quarantine in place. Does that make sense? I can give you a section, 8.1, 20 ILCS 2305.
And I can tell you won't get in trouble.
He just had a call from the department. And long story short, I said, who was it? And I was there. I can't tell you. I said, well, this is going to be a short conversation. I'm not quarantined. Take me to court.
And you were right, and you'll never hear from them again.
They called back. I got to talk to my supervisor. They called back. So you close your case. Have a good day.
Exactly.
That was on the way here. That was the thing. They can't.
I got to tell you, the first time I heard your name
Yes, sir.
was exactly what you were talking about, when you were trying to help all the restaurant owners.
Yes, sir.
My wife and I used to drive to Peoria to eat at a restaurant over there, and that guy was so proud. He brought your letter out, passed it all around, everybody in the place read it. I'm not kidding you, I was really impressed, and
You know what I was given?
I'm glad that we were standing up for them people, because it was important to him.
And you know what I gave them? I gave them courage to stand up for themselves.
Absolutely, and you can't believe how many people were going, I'm not kidding, we were at the restaurant to eat, it was full. There were people, no mask, no shit, he was probably that letter, passing it around.
I had
Everybody in that place read it, and it meant a lot to people.
I had people call me all over for times that don't even know me, telling me that they were so thankful that I was able to help keep their business owners open because they wouldn't have been able to pay their rent.
Absolutely.
Right? And all I was doing was giving them courage to stand up for themselves, just like I've been talking today about the rules of the health code or the school code. It's the same thing. And you would be surprised at how many business owners, when I gave them the courage to say, if they want to close your business, this is how it has to happen. Yeah. And once they realized that it was all a big bluff, they got angry.
Well, it was pretty much, the letter just said, hey, leave him alone, you know.
It said
there was
under
nobody to contact him without going to you or you being present, and the whole letter was like, it just told everybody kind of.
Remember when I told you the law requires consent or a court order to put a person under restricted movement? It requires the same thing to close a business and make it off limits to the public. It's the same law. It's the same section. It's the same provision of the law, sir. So when the health department knew that, and again, leave the governor's mandate about it. How many times do you think a health department tried to close down a business to make it off limits to the public under the Department of Health law that says that being open was a danger because of the state law? Zero.
They used the liquor commission around here.
They tried to use a liquor commission some. They tried to use a food ordinance some. How many times did they try to use the executive order? Never, because they couldn't. It's really that simple. Any other questions? Anybody? Private employers, as of right now, have that discretion, and it's sad, but there is no basis in the law. Could it develop later? You know, I personally like the argument that since it's an emergency use authorization, that your right of privacy to choose what you want to be injected with or not should supersede an emergency use drug. Maybe when it's approved, we could have a different conversation. I personally believe that as long as it's emergency use, that privacy rights should be paramount. That's never been developed in a courtroom yet. It'll take a long time should it ever happen. And in the meantime, employees are in between a rock and a hard place is where they're at. What's that? Yeah, it's a federal issue, but again, somebody's going to take that to court. In the meantime, you'll be unemployed, not have a job, and you're arguing some, federal issue that would take forever, be expensive, and practically, you know where that's at, right, sir?
Where did that lawyer thing again?
I don't worry about it.
Yes, sir. I figured you'd be talking more. You're sitting there and looking all like,
I understand all
you're
this.
playing that role. You got a lot going on and thinking about everything we're talking about. I like it.
So there's two paths, obviously influencing school board members to read this and get on board, but as parents, we have another option, civil disobedience. We could send kids in without masks.
True, and if you could get, again, I don't ever promote that because it's not my role, but if 5 or 10 kids do that, parents versus 500.
What are they, if they expel or suspend a student? Is that, you're not getting legal advice here.
Yeah, I mean, and again, could they threaten it? I mean, you got school board members here that know how that works. Could they threaten it? That's intimidating stuff, right? And so, putting the kids in that position, that's tough, and I would never advocate it, even if I believed that expulsion or something was not possible. I think the best remedies are the political ones and not putting the children. But certainly it's a conversation for parents to have, sir.
Tom, can you address briefly, there was a case in Virginia just the other day, the professor, George Mason University, he was supposed to get vaxxed, and then he said he had robust natural immunity, and the judge ruled that since he had robust natural immunity, it was an unnecessary medical procedure to get vaccinated. So that case just happened. Are you familiar with that?
I'm not familiar with it, but it, again,
just happened.
it's probably a state case. The state laws of Virginia are completely different. Do they have some state law that says that you have the right to choose certain medical intervention? And private employers maybe not be able to punish you or to fire you if you choose. It's probably something along those lines. But again, that law would be specific to that state. And I know of no such law in the state of Illinois. You have the Healthcare Right of Conscience Act, but that really goes to religious morality, and it's a very hard issue. Just because you personally believe that policy-wise you shouldn't have to do that, I don't think gets you there. But whatever happened in Virginia, I'm assuming it's a specific law.
Well, you said too that only applies to medical services or medical like hospitals, that sort of thing, nursing homes and hospitals, that Healthcare Right of Conscience Act.
I think, again, I haven't read it in a while. I think it also says it applies to private as well as public. Yeah. But again, I haven't read it in a while, but people ask about that all the time. But again, really drilling down into whether or not people's objections are grounded into a bona fide tenet of religion versus it just being a personal desire that they don't, that stuff is very complicated. And again, puts people in the same position of, yeah, you can take that argument on while you're unemployed and looking to feed your family. It's really tough.
I'm trying to get people to say what's coming next. And, now we have the sex ed bill. We have, could there be forced vaccinations? Could there be, you're trying to.
The legislature can force vaccination.
Right. Yeah. Right. We're just saying this is coming, and.
There's a lot of this stuff coming. I mean, what's happened between, who remembers 2 weeks to flatten the curve? Right? How was that, a year and a half ago?
Over 81 degrees kills the virus, alcohol kills the virus.
I mean, that's the dangerous thing about what we've experienced the last year and a half, you guys, is that, and I'm not talking about Governor Pritzker, I'm not talking about Dr. I'm talking about just the nature of what we're dealing with. This government appreciation of how easily it can push around the people is dangerous. I don't care who's the party. I don't care who the party is in office, you guys. It's not a Republican or Democrat thing. We have to, as people, make sure that we use the lessons learned the last year and a half to say, you know what? I don't care what party's in office. We're going to govern ourselves appropriately, and the people are still in charge. Because as of right now, it's getting better than it was a year ago. There's some level of appreciation. They may not think we're in charge, and we are, you guys. I promise you. You can convince people to do weird things when they're scared, sadly. Anybody else?
Thank you.
All right. You're welcome. All right. I think we've got one more question. Yes,
One
sir.
more question. So I think you're hearing that all the schools represented here today are willing to go in on your plan.
Okay.
How can we make sure that we get that information?
I'll give you my email address. Like I said, I'm headed north to tomorrow to meet with the people that we're doing all this with, and you can email me, and I'm going to start working on making sure we get this orchestrated. Because again, the question needs to be answered for every school district, and I'm willing to accept that if a court wants to make the decision that this is compulsory on you, they're going to at least clarify it for you in such a way that you may not like, but you'll understand the answer. And again, if it really displeases us enough as citizens, we're going to go to the legislature and say, you know what, the court construed this in a way that we don't believe is in the best interest of us as people. You better change it, right? And if we can't get the legislature to change it, should a court rule in a way that, you guys might not want, that's the legislative process, and we have to appreciate it. But this unknown that we're living in with right now is a disservice to the people of the state, and I believe that unknown is being taken advantage of by people in government, and it's disheartening. All right, thank you very much.
Thank you.
Hey, I ask all of you, please
put your chairs back in, take your trash, put it out on the bar. The Legion would appreciate it. Thanks, Tom, appreciate it.